vaccinated. Can I ask the Honourable Minister what is the status of those students?
Mr. Speaker, sir, all students who haven't been vaccinated are being asked to go to the special medical panel at the level of the Ministry of Health, and they are being provided with, you mean to say those who are exempted?
Already at the age of 18, but had not the opportunity to be vaccinated or could not be vaccinated for some medical reason.
As far as the schools are concerned, we haven't had any cases of students not being admitted because of lack of vaccination card. Now, at the level of the university, we have already provided the facilities for them for vaccination, and those who cannot be vaccinated for a specific health condition, they are being provided with the exempt card from the Ministry of Health.
Question, Mr. Speaker. Currently, our school are working 2 days for lower classes and 3 days for higher classes. Can I ask the Honourable Minister, when does she expect for things to get back to normal? That is a 5-day working class.
Mr. Speaker, sir, we are all waiting for the time when all our students can go to school the way they used to go earlier. However, we will still have to wait for the advice of the Ministry of Health before we go back to that state of affairs.
Table is advised that PQB 869 will be replied by the Honourable Minister of Land Transport and Right Life, Minister of Foreign Affairs, Regional Integration and International Trade. Next question.
Yes, B865.
Mr. Speaker, sir, the Portray Central Market Renovation Project concerns the upgrading of the wing housing the fish, meat and poultry section, and its renovation is long overdue. The Central Market, in addition to being located in the buffer zone of the Upper Vasigat World Heritage Property, is also a heritage building. Accordingly, all proposed development within the buffer zone requires a prior clearance of UNESCO. The Ministry of Arts and Cultural Heritage has appointed a consultant in February 2021 to carry out an overarching heritage impact assessment and a visual impact assessment for projects falling into the buffer zone. In this connection, the consultant is carrying out regular meetings with the relevant stakeholders, including the Municipal City Council of Port Louis, for the renovation of the fish, meat and poultry section. Mr. Speaker, the start of the renovation work will depend on all the work will start depending on upon all the clearance being obtained from UNESCO.
Speaker, as rightly pointed out by the Honourable Vice Prime Minister, the renovation of the Central Market of Port Louis is long overdue. In fact, my first PQ to this matter dates back to 5th July 2016. And since then, almost every year, I have come with a PQ to this House. So my question to the Honourable Vice Prime Minister is, I've gone through all the several PQs that have been asked by myself. It's only last year that it came to our knowledge that we need a heritage impact assessment. And before that, there was no question of this cultural heritage, because it's only a renovation of the market inside the market. So can I ask the Honourable Vice Prime Minister, why is it after 5 years that this is on the table and this is also delaying the renovation of the project, of the market?
Actually, this renovation, even if it's a renovation, it requires the authorization from UNESCO because it falls in the buffer zone, Mr. Speaker, sir. So unfortunately, because as you know, we have already advertised for the consultant service and we've got a consultant. He's been working on it, but then we were told that we have to go to UNESCO. Unfortunately, it takes a long time. Going to UNESCO, you have to prepare an overarching HIA-VIA, and after that, once we get the report, we have to send it to UNESCO. That's going to take quite a few months as well for them to approve it. And after that, again, you have because the overarching HIA-VIA concern about 8 projects near the Upper Vasigat area. Then, after we've got the overarching HIA-VIA, we have to get the individual HIA-VIA of the individual project. For example, you have 8 projects there. You have the Intercontinental Slavery Museum, Art Gallery, Granary, Military Hospital, Portly Central Market, Immigration Square Urban Terminal, Metro Express Light Rail Project. So each of them would have to get an individual HIVIA. Unfortunately, that's how it is. I do appreciate it's taking a long time, but to tell you frankly, it's a bit beyond our control, I must say.
Mr. Speaker, the House will agree, and I'm sure the Vice Prime Minister will also agree with me, of the very unhygienic conditions at the central market. Not only unhygienic, but the electrical works date back to very long ago. The water system est dépassé complètement. So I will urge the Vice Prime Minister, since this project has been on the cards for more than 5 years, that we need to accelerate this project.
Mr. Speaker, sir, as I've explained earlier, we have to go through this process. We can't do any repairs even in this building without the authority of UNESCO. So I appreciate that. I know the problem. I've been getting this kind of complaint from these people who work in the market. Personally, they came to see me. I am aware of the situation they're working in. But unfortunately, we cannot progress with the work until we get that done.
Last supplementary.
Thank you. I would agree with my colleague, Honorable Ami Amia, and may I ask the Honorable Minister if he has the opportunity to effect a site visit at the central market and to see the deplorable condition in which the market is at the moment. The more so we are opening our frontiers to tourists, because each and every market stall owner over there keeps on making complaints like trees are about to fall down, there are tents all over the place, waste lying on the floor,
What is the question?
cameras not functioning. My request to him, would he consider...
No question.
It's a question.
Request is a question. I don't know.
Can I ask the Honourable Minister whether he would consider effecting a site visit at the earliest possible occasion?
Mr. Speaker, sir, I've just replied. I've met those people who are working in the central market. I've got this complaint. I know about the complaint, and I've explained to them. Unfortunately, it's going to take time. It's just beyond our control. I've explained because we have to get the UNESCO clearance before we do anything. So that's why we are taking time. I do appreciate the situation. I do appreciate, because I've met these people working there in person. So it's not a question I'm not aware of it. But that's how it is, unfortunately. It's going to take at least minimum, maybe about 9 to 1 year before we can get the whole clearance to do any work. That's the minimum.
Next question.
Yes, B866.
Monsieur le Président, le Solidarity Levy a été introduit lors de l'exercice comptable 2017-2018. Avant cette date, et depuis le 1er juillet 2007, le régime fiscal mauricien était basé sur l'imposition des revenus des personnes physiques à un taux unique de 15%. Ce taux était applicable à tous les contribuables, quel que soit leur niveau de revenu. Afin d'assurer plus de justice sociale, il était impératif de rendre notre système d'impôt sur le revenu progressif. C'est dans ce contexte que le Negative Income Tax, mesure de lutte contre la pauvreté, a été introduite à partir de juillet 2017. Dans le même temps, pour réduire davantage les inégalités, la décision avait été prise d'introduire un Solidarity Levy sur les hauts revenus. Ainsi, à partir de l'année fiscale 2017-2018, les personnes physiques ayant un revenu annuel imposable plus dividendes dépassant 3,5 millions de roupies ont été soumis à une taxation de 5% de l'excédent du seuil mentionné au moment de la soumission de leur déclaration de revenus. L'année suivante, c'est-à-dire à partir de l'année fiscale 2018-2019, il a été décidé de réduire la charge fiscale des personnes à revenus moyens et de rendre notre système d'impôt sur le revenu des personnes physiques plus équitable. Le taux de l'impôt sur le revenu a donc été réduit de 15% à 10% pour les personnes gagnant un maximum de 50 000 roupies par mois. Monsieur le Président, l'aide aux personnes vulnérables, la réduction de la charge fiscale pour les personnes à faible revenu et l'imposition de ceux qui ont les moyens ont toujours été la pierre angulaire de nos réformes. Ces principes ont également prévalu lors de l'introduction du Wage Assistance Scheme et du Self-Employed Assistance Scheme afin de protéger les moyens de subsistance des travailleurs affectés par la pandémie de la COVID-19. Dans la même veine, À partir de l'année fiscale 2020-2021, un appel patriotique a été lancé à ceux qui gagnent le plus en révisant le contour du Solidarity Levy. Le prélèvement est désormais applicable au taux de 25% sur le revenu imposable annuel plus les dividendes au-delà de 3 millions de roupies. Il est plafonné à 10% de la somme des revenus nets et des dividendes de la personne physique. La Mauritius Revenue Authority m'a informé qu'un montant total de 3,46 milliards de roupies a été collecté au titre du Solidarity Levy depuis son introduction jusqu'au 30 juin 2021. Un peu plus de précision, en juin 2018-2019, il y avait 2830 individus qui avaient contribué à cet impôt et le montant collecté était de 614 millions de roupies. En 2019-2020, il y avait 3052 individus qui avaient contribué à cet impôt et le montant collecté était de 787 millions de roupies. Et en 2020-2021, il y avait 3338 individus qui avaient payé cet impôt et le montant collecté était de 2 milliards 57 millions. Merci, Monsieur le Président.
Next question.
B867.
Mr. Speaker, sir, the Traffic Management and Road Safety Unit carried out a site visit at the Calcutta Street in Port Louis from its junction with Saint François Xavier Street to Little Bridge Street on the 29th of July 2021. I am advised by the TMRSU that traffic congestion occurs only when school vans and parents drop and pick up their children near the Nur Islam Madrasa from 8:30 hours to 9:50 hours in the morning and 13:30 hours to 14:15 hours in the afternoon. But in order to alleviate traffic congestion at the said locus, the Calcutta Street will be converted into a one-way road during school peak hours from 8:30 to 9:50 hours in the morning and 13:30 hours to 14:15 hours in the afternoon from the junction Calcutta Street, Little Bridge Street to junction Maratha Street. The works in relation thereto will be completed within 2 weeks, and enforcement will be done by police during the peak hours. So I think my friend should be very happy.
Mr. Speaker, although I appreciate the measure announced by the Honourable Minister, but why not make it permanent? Why the TMRSU is only applying it for school hours? Because as you are aware, the roads in Plainvert are very small, very narrow. It dates back to more than 200 years, and many of them has already been transformed on one way. I think this should have been a permanent measure, because I've spoken to not only the responsible officer of Nur Islam Madrasa, but also to the people living in Wynn Street, and they are totally agreeable that this road be converted one way full time.
Dans un premier temps, Monsieur le Président, let us stick to what the TMRC has proposed. I am open. I'm sure the TMRC also is open. We will monitor the situation, and if need be, we will go by what the honourable member is proposing. But for the time being, the TMRC has proposed that the one way would be effective only during school hours. Let's do that, and I can assure my honourable friend that in case we need to decide that the whole street should be a one-way 24 hours and 24 hours, we'll do that.
Since this will be done, I'm sure the Honourable Minister will agree with me that proper notice board and sign marks will be placed there, because it might be difficult for the people there to know exactly what are the hours concerned.
Of course, Mr. Speaker, sir. As I said, the time frame for the implementation on the one-way scheme will be 2 weeks, so as to enable for the preparation and installation of the traffic signs. The installation of the traffic signs also involves the painting of a supplementary plate indicating the time which will be added under the traffic sign. So the honourable member should not be worried about that.
Dr. Mia.
Thank you, Honourable Speaker. B868, please.
Mr. Speaker, sir, with your permission, I wish to reply to PQB B868, B881, and B884 together, as they relate to maternal and neonatal services in the public health institutions. In reply to PQ B868, I wish to inform the House that an intrauterine fetal death is the death that occurs in utero or during delivery after the completion of the 20th week of pregnancy, and a stillbirth is the birth of a baby that has died in the womb after having survived through at least 28 weeks of pregnancy. Mr. Speaker, sir, over the past 3 years, that is from 2018 to 2020, there were 3 cases of intrauterine fetal deaths and 253 stillbirths in our hospitals. In 2018, there was 1 intrauterine death at G2 Hospital and 1 at SSR Hospital. And stillbirth, 30 at G2 Hospital, 14 SSR Hospital, 13 Bruno Chong Hospital, 6 Nehru Hospital, and 15 Victoria Hospital. In 2019, there was 1 uterine death at SSR Hospital and stillbirth, 26 G2 Hospital, 16 SSR Hospital, 13 Bruno Chong Hospital, and 17 Nehru Hospital. 21 Victoria Hospital also. In 2020, there was no case of intrauterine death in our 5 regional hospitals. However, there were 31 stillbirths at G2 Hospital, 21 stillbirths at SSR Hospital, 10 stillbirths at Bruno Chong Hospital, 11 stillbirths at Nehru Hospital, and 9 stillbirths at Victoria Hospital. From January 2021 up to 30th June 2021, there were 1 intrauterine death at SSR Hospital and 1 at Victoria Hospital. Stillbirth during this year, 15 at G2 Hospital, 12 SSR Hospital, 5 Bruno Chong Hospital, 9 Nehru Hospital, 8 Victoria Hospital. Mr. Speaker, sir, with regard to Part A of the question, I am informed by the Commissioner of Police that from 2018 to 30th July 2021, there were 10 cases of intrauterine fetal death and stillbirths reported to the police for inquiry. Of the 10 cases, 6 have been classified and 4 cases are still under inquiry. I wish to inform the House that there was no formal complaint for 2018. For 2019, 1 case of stillbirth and 1 case of spontaneous abortion and 2 cases of intrauterine fetal death were reported to my ministry following complaints from the aggrieved parties. Mr. Speaker, sir, I am also informed that after the investigation, the reports were submitted to my ministry and 1 case was referred to Medical Council as the committee was of the view that there was medical negligence. Regarding cases for 2020, my ministry was notified about an alleged case of a stillborn baby. The said case has been referred to the MNSA and is currently being investigated, and a report will be submitted shortly. For 2021, 2 cases of stillbirth have been the subject of an investigation at the level of the Medical Negligence Standing Committee. 1 report has already been finalized and referred to Medical Council. As for the 2nd case of stillbirth, the Medical Negligence Standing Committee is presently investigating into it. Mr. Speaker, sir, as regard to Part B of the question, I wish to inform the House that in 2019, there were 8,381 live births and 94 stillbirths in the public hospital. That is 1.1% of stillbirth, compared with 3,639 live births and 36 stillbirths in the private health institution, representing 1% of stillbirth. In 2020, there were 8,462 live births and 93 stillbirths in the public hospital, compared with 4,5 55 live births, and 40 stillbirths in the private health institution. These statistics demonstrate that clearly that there is public confidence in our maternal and neonatal services. Besides, the costs incurred for a normal delivery in the private clinics vary between 70,000 to 75,000 and to 90,000 to 120,000 for a cesarean section delivery. According to the cost center projects, government incurred 17,440 for a normal delivery and 20,250 for a cesarean section in our public hospital. To further strengthen public confidence in our maternal and neonatal services, my ministry has taken the following measures. There is preparation of a pre-conception care program. The NICU beds capacity has been increased by more than 50%, from 23 to 35, and the infrastructural works for the construction of a national tertiary neonatal intensive care unit by mid-September 2021 has already begun. New treatment modalities have been introduced, namely the cooling therapy to prevent brain damage, injuries in baby born with perinatal asphyxia, and nitric oxide therapy for management of babies with pulmonary hypertension and refractory hypoxic respiratory failure. There is an ongoing advanced training in medical and nursing staff in neonatal intensive care unit. Strict infection prevention and control measures are taken in all neonatal intensive care units to reduce infection and prevent sepsis, with the setting up of a national infection prevention and control committee in the 5 regional hospitals as from this year. Implementation and harmonization of management of neonatal intensive care units by following established guidelines and protocols. Mr. Speaker, sir, in order to address issues in relation to neonatology, not later than last week, I chaired an online meeting with Dr. Simpson Clark, who is a neonatal consultant and the Vice President for Policy at the Royal College of Pediatricians and Child Health in UK. Dr. Clark is expected to come to Mauritius in October this year to conduct an assessment of the neonatology units of our 5 regional hospitals. This has been made possible thanks to the intervention of Dr. Gopal, the consultant in charge orthopedics and presently the acting regional health director at Victoria Hospital. I'm also informed that Dr. Simon Clark would conduct an independent medical audit of the maternity services and neonatal deaths of the 5 regional hospitals and advise on the best practices to improve the whole neonatal service. In addition, Dr. Clark would offer his support in the implementation of the neonatal guidelines and protocols to standardize the neonatal practice in Mauritius. Mr. Speaker, sir, in reply to PQ B881, I wish to inform the House that in February 2019, a committee of inquiry was set up by government to inquire into cases of maternal death in Mauritius. The committee is chaired by a former judge and is assisted by a specialist in obstetric and gynecology. The terms of reference of the committee of inquiry are to examine, inquire into causes and circumstances leading to maternal death, assess facilities available at prenatal and postnatal wards, and make recommendations to address any shortcomings to prevent maternal death and improve maternal service in general. The committee of inquiry is finalizing the report of inquiry and will be submitting same in the last quarter of this year, after finalizing inquiries on maternal death in Rodrigues. It is worth mentioning that the work of the inquiry committee has been hampered due to the lockdown in respect of the COVID pandemic. Mr. Speaker, sir, in reply to PQ B881, I am informed that as at July 29, 2021, there is a total of 18 incubators at Victoria Hospital, of which 14 are operational and 4 under repairs. there is a total of 15 incubators at G2 Hospital, of which 13 are operational and 2 are under repairs. There is a total of operational. Nehru Hospital has a total of 12 incubators operational and 3 are under repairs, and 1 is under repair. I'm further informed that as compared to 40 incubators in 2016, there are now a total of 72 incubators in all regional hospitals. Mr. Speaker, sir, I wish to inform the House that my ministry has already procured 20 infant incubators this year, with warmers which have been distributed as follows: 10 to the new National Tertiary Neonatal Intensive Care Unit at Victoria Hospital, 6 at G2 Hospital, 1 at Nehru Hospital, 1 at Bruno Chong Hospital, and 2 for SSRN Hospital. Mr. Speaker, sir, my ministry has also procured 14 neonatal closed incubators with integrated pulse oximeter, which would be used at 4 level 2 neonatal and intensive care unit. The 14 new neonatal closed incubators have been distributed as follows: 5 to Victoria Hospital, 5 to G2 Hospital, 2 to Nehru Hospital, and 2 to SSRN Hospital.
Thank you, Minister, for your detailed answer, and surely I do welcome Professor Simpson-Clark from the Royal College of Pediatricians, whom I'm sure will do a very brilliant job when he comes over. The increasing number of preterm and extreme preterm babies do surely add to the numbers that you have given us over the last 5 years as concerns in uterine death and stillbirth. Can I have from the Minister why the Ministry is now, only this week, convening a meeting to be organized with regard to put a protocol in place with regard to gestation viability of these babies who have to be considered for active resuscitation and treatment, which I'm sure is very long overdue for our clinicians in the hospitals. Thank you.
Mr. Speaker, the protocol has been worked out since in the beginning of this year. Now, concerning this week, last week we have a meeting with Professor Simpson-Clark. It's based mostly because of the opening of the borders, and then we can arrange his visit in Mauritius.
Merci, Monsieur le Président. Le ministre peut-il informer la Chambre s'il a reçu une lettre de Madame A de Taillac, dont les triplés sont morts à l'hôpital de Rosebel le 18 avril et le 19 avril, sur le fait que ces 2 bébés lui sont restés dans le ventre après 24 heures du premier accouchement, alors que l'hôpital aurait dû provoquer cet accouchement par césarienne? Est-ce qu'il compte entamer une enquête à partir de la lettre envoyée par Madame A?
Mr. Speaker, sir, I am aware of this case, and the inquiry, the Medical Negligence in Standing Committee, is already inquiring on this case.
Monsieur le ministre, répondant à la question, vous avez donné des chiffres qui sont vraiment effrayants et alarmants. Et vous le savez mieux que quiconque, Monsieur le ministre, que bien souvent dans les enquêtes qui se sont déroulées, nous avons vu que les médecins, les spécialistes, bien souvent ne sont pas physiquement présents dans les hôpitaux et ils donnent par téléphone des fois des prescriptions. Est-ce qu'on peut savoir de vous, Monsieur le ministre, quel est le mécanisme que vous avez mis en place pour s'assurer que de façon permanente, des spécialistes, que des pédiatres ou des gynécologues ou les anesthésistes soient présents physiquement, 24 heures sur 7, comme demandé dans le rapport du PRB?
Mr. Speaker, sir, the first part of the question is related whether the figures are alarming. In my reply, I made the comparison between the public service and that of the private sector. I even made the comparison about the cost incurred in the private and then in the public sector. We all have seen that the figures, they don't differ much, and in that, I don't think that the figures are alarming. Now, the other part of the question is related to whether the doctors who have been subject to an inquiry, who haven't done their work properly, there are there are the councils who investigate on such cases. There are medical tribunals who investigate on such cases. And wherever doctors or whoever been, they haven't done their work properly, they are subject to sanctions, and sanctions have been happening whenever such cases do occur. Now, as part of the third part of the question, Honourable Member, rest assured that the Ministry is working on the implementation of having doctors, especially gynecologists and pediatricians, to be in the hospital. Now, we don't have the numbers, and because of that, I think in the past I've given a reply in this House that we are going to have a registrar post. We're having a registrar post created so that this can comble that missing part of not having the specialist, but at least having somebody, a registrar, who's much experienced to be there on 24 hours basis. The time will come when we'll have sufficient specialists so that we can have this service at a 24 hours.
Thank you, Speaker. Can the Honourable Ministers inform us whether his ministry, particularly the Chief Medical Officer, have a droit du regard in terms of recommending either stepping down, continuous supervision by the consultant in charge, retraining and reappraisals of the very few specialists whose names come up repeatedly involved in alleged negligence over the last couple of months. Thank you.
Mr. Speaker, sir, the CMO, that is the Director General, and other directors in the health service with the Chief Executive Officer, once an inquiry is done at the level of the ministry, last time Honorable Kiran did ask me to submit the report, and where actions have been taken immediately. That is, once the report is available, and based on the report, the recommendation of the report, doctors have been suspended, doctors have been requested to step down or for further training or not to be on call. There are different measures that have been taken, especially when we know that we have to face cases of negligence or any issues related to negligence.
Merci, Monsieur le Président. Concernant la question du nombre d'incubateurs dans nos hôpitaux, est-ce que j'ai bien compris qu'il n'y en a pas à l'hôpital de Rosebel?
No. Yes, there are incubators at the Nehru Hospital. I think I've mentioned it in my reply that at Nehru Hospital we have 12 incubators. Yes, Nehru Hospital has a total of 12 incubators, of which 9 are operational or 3 are awaiting repairs. I understand that you have read on newspapers or getting information. Please come to me, I will confirm it, I'll give you the right information.
Excusez-moi, Monsieur le Président, je n'ai pas lu dans la presse, c'est la dame elle-même qui m'en a parlé. Donc c'est pourquoi je pose la question. Pourquoi, vous me dites, le ministre vient de me dire qu'il y a ou plusieurs incubateurs à l'hôpital Nehru. Pourquoi dans ce cas, le 3e bébé de la Madame a dû être transporté de Rosebel à Flac?
Because, Mr. Speaker, the answer is so simple. Other incubators, there are other babies in those incubators.
Next question. You have a last one? That would be last one.
Sorry?
You can put your last supplementary.
Donc je disais, j'ai oublié.
C'est pas grave. Team.
E869.
Mr. Speaker, sir, with your permission, I shall reply to this question. I presume that the honourable member is referring to the combined 20th to 23rd periodic reports on the International Convention on the Elimination of All Forms of Racial Discrimination. In view of the fact that the combined 24th, 25th periodic state reports were submitted in June 21 and no recommendations have been received as yet. It is to be noted, sir, that the state report was submitted to the Convention on the Elimination of All Forms of Racial Discrimination Committee in July 2017. The review was held in August 2018, and the concluding observations and recommendations received in September 2018. Cabinet was apprised of the concluding observations and recommendations and decided in September 2018 to set up a ministerial committee to look into same, as issues would have a far-reaching bearing on the social fabric of the Mauritian society. The committee was chaired by the Honorable Mrs. Jiwa Doriaou, then Vice Prime Minister, Minister of Local Government and Outer Islands, Minister of Gender, Equality, Child Development and Family Welfare, and was composed of Honorable Mrs. Dukan Lachman, Minister of Education and Human Resources, Dr. Honorable Mr. Asnu, the then Minister of Health and Quality of Life, Honorable Mr. Gobin, Attorney General, then Minister of Justice, Human Rights and Institutional Reforms, Honorable Mr. Sinatambu, the then Minister of Social Security, Honorable Minister Wong, the then Minister of Social Integration, and Honorable Jagru, the then Minister of Housing and Lands, and Honorable Boissaison, then Minister of Civil Service and Administrative Reforms. The Ministerial Committee reviewed all the 26 recommendations made by the third committee and reached the conclusion that certain of the recommendations should not be implemented. Cabinet agreed thereon. The reasons for the non-implementation of the recommendations, as well as the status report of what the state has achieved since the last review, are incorporated in its combined 24th and 25th periodic reports covering period July 2017 to May 21. Same has already been transmitted to the third committee and is available on both the website of the Office of the High Commissioner for Human Rights and that of the Human Rights Division of my ministry. The reasons as to why certain recommendations made by the committee following the last review will not be implemented are inter alia, that disaggregated data by ethnicity are not kept as a rule, as it goes against national unity and nation building in a rainbow nation which the government believes in and fosters. B, the Republic is a land of immigrants, everyone is equal, as such special measures are implemented for all vulnerable groups irrespective of their race or ethnicity. C, given that Mauritius is geographically small and is among the most densely populated island states, it has limited resources to provide the core basic services that will be required to migrant workers and members of their families. And lastly, there are presently adequate avenues of redress in the Mauritian legal systems against violation of human rights.
Thank you, Mr. Speaker. Sir, the Committee on the Elimination of Racial Discrimination in its concluding remark stated, and I quote, at paragraph 6, the committee regrets the state party's persistent position not to collect data disaggregated by ethnicity, which in the view of the committee impedes the assessment of the enjoyment of human rights by different ethnic groups present in the state party. Doesn't the Honourable Minister agree that the reason why the government does not want to collect these data is precisely because it will demonstrate an unequal enjoyment of certain rights under the Convention as far as employment, education, health, and housing issues are concerned, as has been claimed again and again by Affirmative Action in its report to the United Nations?
I don't think we subscribe on this side of the House to the proposal that any component does not have effective access to employment, adequate housing, healthcare services, or pensions, or employment, Mr. Speaker. Sir, no, we do not subscribe to this view, but this question of keeping the disaggregated statistics can be replied by the fact that we do not keep such records because we would think that this is stigmatizing components of our society. Keeping such data, Mr. Speaker, will be against national unity. We are a land of immigrants, Mr. Speaker, sir. We came to this island as slaves, merchants, or laborers. we are equal in the Republic of Mauritius. And special measures we know are implemented for vulnerable groups of all components of this society, irrespective of their race or ethnicity. And the Republic of Mauritius favors nation building and not division, Mr. Speaker, sir.
I'm glad to hear the Honourable Minister say what he's saying now, because when he was in the opposition, that was not the language he was saying. But anyway, doesn't the Honourable Minister agree? Doesn't the Honourable Minister agree that being given that he has nothing to hide,
has always been against
he has nothing to hide? Let me answer. Let me ask the question, then you can answer. Being given that the government has nothing to hide, will he publish, so that everybody knows, all the appointments that has been made by this government when it comes to appointment of board members, chairperson, which is not under PSC, but is done by minister, by cabinet, so that everybody in Mauritius can see what is the equal opportunities, equal enjoyment of rights as far as employment is controlled.
Mr. Speaker, sir, there was a recommendation to that effect. As I just said, there were 26 recommendations which were made, and 16 of them were accepted, were taken on board, and 10 were not accepted, Mr. Speaker, sir. And among the 16 recommendations which were accepted is precisely one which the Honourable Member just referred to.
Move to your next question.
I have one last question on this.
Last one.
Yes. Under paragraph 29 of the committee's recommendation, the committee recommends that the state party takes necessary measures to confer to the Creole language the status of national language with a view to facilitating its use in the administration, judicial and education systems and preventing the social exclusion of those who are of Creole speaking only. So I know from the Honourable Minister why in its views advanced, which has been deposited, which has been given to the United Nations, government say that they are not going to implement this recommendation to give the Creole language the status of a national language.
Mr. Speaker, sir, with regard to the Creole language, we all know that the Creole language is, and this is in the report, Mr. Speaker, sir, that we sent, is mostly is used in the country, in the different fora. The use of Creole language is today acceptable in the administration, even in the judicial and education system, Mr. Speaker, sir. And we all know that government is proceeding in a phased manner. And to this end, in May 2019, government decided to set up the Académie Créole République Maurice to follow up on the development and the use of the Creole in the Republic of Mauritius. With regard to education, Mr. Speaker, sir, we know what progress we are making. A few weeks ago, the Honourable Minister of Education on the 25th of May made a statement with regard to the rolling out of the Creole Mauritian at the upper secondary level in the wake of the recommendation made by the Ministerial Committee chaired by the Prime Minister, Mr. Speaker, sir. As you know, this committee came up with a roadmap for the unfurling of Creole Mauritian at upper secondary level. So we are making progress on that score, but what we must say also is that language is a qualification prerequisite for certain jobs and opportunities. And therefore, because there are very often in the recruitment process the necessity for language to be a qualification, prerequisite for certain jobs, therefore, at this stage, it would not be appropriate to include same as a ground of discrimination.
The next question.
B870.
Mr. Speaker, so with regard to part A1 of the question, I'm advised that the Land Research and Monitoring Unit is at present staffed as follows: 1 principal surveyor, 1 survey technician, 1 management support officer, and 1 word processing operator who are from the establishment, who are on the establishment of the Ministry of Housing. In addition, the services of 2 private land surveyors and 2 private attorneys have been retained since July 2020 and October 2020, respectively. They are presently attached to the LRMU, the Land Research and Monitoring Unit. With regards to part A2 of the question, I'm advised that 46 cases had been entered by the claimants themselves prior to the coming into operation in July 2019 of the Land Research and Monitoring Unit. Now, the Land Research and Monitoring Unit has investigated 309 cases, as a result of which the present situation is as follows. 20 cases are to be lodged in court. 184 cases are still under investigation. 105 cases have been deemed not to be pursued further. 41 cases pertain to alleged land dispossession in Rodrigue and are therefore awaiting a mission to Rodrigue by the Land Research and Monitoring Unit, COVID-19 permitting. Mr. Speaker, sir, as regards part B of the question, I'm advised that as at July 2021, some 5.5 million rupees have been spent.
Thank you, Mr. Speaker, sir. May I know from the Honourable Deputy Prime Minister the names of the 2 attorneys and 2 land surveyors and the terms of their appointment, how much they are paid?
Certainly, Mr. Speaker. I'm grateful to the Honourable Gentleman for giving me the opportunity of providing information on this issue. Now, as regards the, let's see now, the surveyors. Now, there was a request for proposal. There was an advertisement in September 2019. This could not go ahead as the land surveyors were not interested. Then in March 2020, there was another request for proposal whereby 45 sworn land surveyors registered with the Professional Land Surveyors Council were invited to submit their applications according to certain criteria. 6 responded. 3 were selected in July 2020. They are Mr. Vinod Siban, Mr. Abdul Razak Bahadur, and Mr. Ricardo Ramia Isabel. Mr. Ricardo Ramia Isabel eventually resigned from the Land Research Monitoring Unit in December 2020, and attempts to replace him have so far proved unsuccessful. But we shall certainly try again. These land surveyors are on a contract basis, of course. Just want to see whether I have the information concerning the land surveyors. I should have it somewhere, but in the meantime, let me provide information concerning the attorneys, which I have at hand.
Maybe you can produce it at a later stage.
Yes, well, the attorneys are Mr. Sibalak and Mr. Ramputab, who were retained in October 2020, and they have an all-inclusive allowance of 85,000 rupees per VAT for 20 hours of work per week. And I undertake to provide information concerning the surveyors.
Honourable Deputy Prime Minister mentioned that only 5.5 million rupees has been spent when we know that an amount of 50 million rupees had been earmarked in the budget for the Land Research and Monitoring Unit. Doesn't the Honourable Deputy Prime Minister agree that there is a need to beef up that monitoring unit so that the money is there? Now we need to have more people so that there is more cases being lodged, because according to him, there's only 20 cases that has been considered in that current year.
Mr. Speaker, the issue is a complex one. I share the frustration of the Honourable Gentleman at the pace at which we are progressing. It's very complex because the report of the Truth and Justice Commission has to be analysed. Each of these alleged land dispossession cases has got to be scrutinised and all the relevant information obtained. The heirs of the owners have got to be found out and liaised with in their individual capacity to have their testimony and get the documents in their possession. Searches have to be carried out at the Registrar General's Department to obtain title deeds and land survey reports and plans. Site visits have to be effected to gather information concerning neighbours and people in the know. The rapport de constat has to be established to get all the relevant information. So a lot of time goes into this preliminary work, which does not entail major expenses. It is being done by the officers involved already. The key issue concerning expenses will come when cases are to be lodged in court. Now, my ministry is presently addressing this matter, which is a policy matter, as to how we proceed once plaints with summons have been drafted by the attorneys.
Last supplementary?
It's okay.
You don't have. Next question.
E871.
Mr. Speaker, sir, on 9th March 2021, regulations were made under sections 79A and 193 of the Public Health Act for any eligible person to either get vaccinated in a public health institution, a vaccination center, or a private health institution. Following inspection by the National Pharmacovigilance Team of my ministry and recommendations made thereon as to the infrastructure and equipment in place, 9 private health institutions were provided authorization to start administration of the COVID-19 vaccines. Mr. Speaker, sir, I'm informed that as of 28 July 2021, 73,000 doses of vaccines for first dose administration and 60,660 doses for second dose administration have been provided to the 9 private health institutions as follows: 10,250 doses of Covishield for first dose administration and 9,520 doses for second dose administration, 14,250 doses of Covaxin for first dose administration and 13,140 doses for second dose administration, and 48,500 doses of Sinopharm for first dose administration and 38,000 doses for second dose administration.
Thank you, Mr. Speaker. Sir, may I know from the Honourable Minister, what has been the criteria used for allocating the number of doses between the various private health institutions? Because he has not answered my question, which was to give the number of vaccines received by each private health institution. So what was the number of vaccines received and what was the criteria to give to each private health institution?
Mr. Speaker, sir, all the private health institutions have been given the same amount of doses in the first instance, depending upon their administration of the vaccines. Then another batch of vaccines have been supplied. So it all depends upon the number of doses that they have already been administered, and then the ministry make provision to give them additional doses. And in the circumstance that they have to give all the information that they have already used the batch that have been given to them in the previous batch given to them.
Each private health institution charges a fee for vaccination of 300 rupees per dose. I know from the Honourable Minister whether this fee has been fixed after consultation with the ministry, or is each private health institution free to charge whatever fee they want for this vaccination?
Mr. Speaker, sir, this fee has been fixed by the ministry under consultation with the private health institution, and this is fixed for all the health institutions, for all the private health institutions.
B872, please.
Mr. Speaker, sir, in accordance with the COVID-19 restriction of access to specified institutions regulations 2021, and for the purpose of preventing the spread of COVID-19 in Mauritius, sanitary protocols have been established for staff, patients, and visitors to have access to private and public hospitals. Therefore, in order to attend to their place of work in either a private or public hospital, each staff must produce his COVID-19 vaccination card certifying that he has been vaccinated with the COVID-19 vaccine. B, in case he has not been vaccinated with a COVID-19 vaccine, a PCR test result slip certifying a negative result dating back to not more than 7 days from the date of the PCR test was undertaken, or a documented medical certificate duly certified by a panel of 2 government medical officers that by reason of his medical conditions, he cannot be vaccinated with a COVID-19 vaccine. In such circumstances, the person will be required to undergo a PCR test at such interval as may be determined by the panel of government medical officers. For visitors to have access on the premises of either a private or public hospital, similar sanitary protocols to those applicable for staff of those institutions have been established. Mr. Speaker, sir, on the other hand, a person visiting a private or public health institution for medical treatment or for the purpose of procuring medicine will not be required to produce proof of vaccination or a negative PCR test. Similarly, no documentation will need to be produced by one other accompanying person.
Merci, Monsieur le Président. L'honorable ministre est-il informé que certaines cliniques privées exigent au public, c'est-à-dire celles et ceux qui se sont déjà fait injecter les 2 doses de vaccin, on leur demande d'effectuer un test PCR pour avoir accès à l'intérieur de leur établissement. N'est-ce pas contraire au protocole?
Exactly, Mr. Speaker, sir. The honourable member is completely right that this is contrary to the protocol, but because the protocol is clearly, as I have already stated, that once you are vaccinated, you can have access, be it you're a visitors or you are a personnel working in that health institution.
J'ai été informé que les cliniques réclament entre 750 roupies et 1500 roupies pour un test PCR rapide. Le ministre ne pense-t-il pas que la pandémie de la COVID-19 soit devenue pour certaines cliniques privées de se faire de l'argent au détriment de la population et ensuite de cela, tout en faisant preuve d'excès de zèle dans l'application du protocole?
Mr. Speaker, sir, yes, if ever we'll have complaints from the public or any other person saying that these clinics are like having different fees or abusing on at a certain amount of money, charging patients or somebody who attended those clinics with, especially for rapid antigen test, the ministry obviously will have to work on it, how again to fix a certain price. So far the PCR test is concerned, generally in all the clinics, compared to what the Ministry of Health is also providing PCR test against payment, the price for PCR test against payment compared to the clinics is more or less the same.
Last supplementary. Next question.
B873, please.
Mr. Speaker, sir, all persons tested positive for COVID-19 are taken to the new ENT hospital or a designated center, including dedicated hotels, senior citizens recreational center, and other institutions to receive treatment. As at now, there are 8 hotels institutions catering for such patients. In addition to the above, persons who have been in direct contact with positive patients are admitted to quarantine centers. As at now, 13 hotels institutions are being used for quarantining these persons. Moreover, provision has also been made for quarantining of incoming passengers. At present, 10 hotels have been designated for this purpose. Mr. Speaker, sir, treatment centers and quarantine centers are made available to my ministry upon request to the Ministry of Tourism. Accordingly, the Mauritius Tourism Promotion Authority acts as a facilitator and provides a list of hotels that can be designated as treatment or quarantine centers. These hotels are thereafter inspected by the Public Health Inspectorate of my ministry, and following recommendations submitted thereon as to their suitability, arrangements are made under the Quarantine Amendment Number 3 Regulations 2020 to designate the hotel as a treatment or quarantine facility. Therefore, the question of overcrowding doesn't arise, as hotels are promptly being made available upon request to the Ministry of Tourism.
Président, j'ai bien écouté la réponse du ministre, mais d'après les informations qui me sont parvenues, cela laisse comprendre que les centres de quarantaine sont bondés. Et je vais dire pourquoi. Car dans certains cas, il y a 2 patients qui ne se connaissent même pas, qui sont contraints de partager la même chambre et de surcroît, Monsieur le Président, le même lit. De ce fait, le ministre peut-il confirmer ces informations et nous dire s'il trouve cette situation acceptable?
Mr. Speaker, sir, the treatment facilities, that is the hotels who have been converted to treatment facilities, they can have 2 patients, that is in one room, they can have 2 patients in that same room. Now, what happens when there is a patient at night that the contact tracing, the rapid response team has already taken him to a treatment center, and for that overnight, we have to accommodate that patient pending the availability of other rooms or the next day. This happens occasionally in some circumstances. Now, about sharing the same room, usually whenever we have treatment facilities where we have the staff of the same company, that is people that have been working in same places, they have been given in the same room. They have been allowed to stay in the same room. Otherwise, people who are, maybe it may happen that they have to stay for a few hours by the time rooms are made available so that patients can be accommodated in other rooms.
Thank you, Mr. Speaker, sir. Can we know from the Honourable Minister whether is his ministry planning any change in the protocol, that is, what is being done compared to what is being done overseas, people staying at their own place of residence and having online regular checkups with their doctors, given that, as I have heard from his previous interventions, that most of the people are asymptomatic and not getting any serious problems from the start of their admission to the end. Thank you.
Mr. Speaker, sir, let me start by saying that those in contact who have been vaccinated are allowed to stay at home, to do self-isolation at home. But concerning treatment, so far, all those who have been tested positive have been placed in treatment centers. Now, obviously, now it will be a time because we have many asymptomatic cases, and especially that many of our patients have already been, who has already been vaccinated, will reach at another stage where treatment will be allowed, that somebody can do their treatment at home. But I think we have to wait a little bit before moving to that stage.
Last supplementary.
Monsieur le Président, je dois rappeler à la Chambre, à l'honorable ministre, que dans ma première question supplémentaire, j'ai fait référence aussi à 2 personnes, 2 patients partageant le même lit. Pas uniquement la même chambre, mais aussi le même lit. Mais passons. Monsieur le Président, l'honorable ministre a-t-il pris connaissance des doléances et les craintes exprimées par le personnel soignant par rapport au manque d'effectifs consécutifs au nombre important de cas positifs enregistrés ces dernières semaines?
Mr. Speaker, sir, there is no, you don't have to be to be afraid of cases. We all know that COVID-19, we know the treatment modalities clearly now. We also know that once you are vaccinated, you are protected. You will not develop severe form of the diseases. The question that medical personnel are frightened about COVID positive, it's no longer that case what we were last year in 2020. Now, again, the staff, deployment of the staff, more cases means more treatment centers, deploying more staff. This is the situation that we are dealing with. I think there is a question that will come next. The next question will be on this only. I will reply. I will give all the answers. The answers.
Move to your next question.
B874, please.
Yes, sir. I'm informed that the Serge Alfred swimming pool is not operational. The temperature sensors of the boiler system of the swimming pool have been damaged by rodents and needs to be replaced. However, the model of sensors required for the system is not available on the local market. A supplier has been solicited for the new sensors. The sensors would be available in 6 weeks. Mr. Speaker, the temperature sensors are required to control the heating process of the swimming pool. Therefore, pending the replacement of the sensors, the swimming pool is closed.
Président, l'honorable ministre doit le savoir, hein, plus de 62 millions ont été dépensés dans la rénovation de cette infrastructure dans le sillage des derniers Jeux des îles. De ce fait, peut-il nous dire comment des problèmes qui ne datent pas d'hier, qui datent de plusieurs années, notamment la chaudière qui ne cesse de tomber en panne et le système de débordement d'eau défectueux sont toujours d'actualité?
Monsieur le Président, comme je viens de le dire dans ma réponse, le problème actuel auquel nous faisons face, c'est le boiler system, donc pour le chauffage de la piscine. Et donc les câbles électriques de ce système ont été endommagés. Le boiler en lui-même, il fonctionne bien, c'est juste au niveau des câbles électriques, des sensors, et donc nous allons remplacer ces sensors. Et pour rappel, le boiler ne faisait pas partie de la rénovation de la piscine dans le cadre des Jeux des îles. C'était pas ça.
Monsieur le Président, le ministre peut-il nous dire pourquoi la proposition du MSC faite au club de la région de Beaubassin pour utiliser entre-temps la piscine de Côte-d'Or a été annulée en moins d'une heure après, selon les informations qui me sont parvenues? Et y a-t-il d'autres alternatives que propose le MSC à ces clubs?
Monsieur le Président, le MSC a voulu trouver une solution par rapport aux clubs qui ont besoin d'utiliser, surtout de s'entraîner. Et donc, je sais qu'il y a eu une proposition qui a été faite par la piscine de Côte-d'Or. Évidemment, je n'ai pas les renseignements nécessaires en ce qui s'agit des frais qu'il faut payer. Donc, bien sûr, cela coûte, il faut payer, parce que je sais aussi que les clubs ont des membres qui payent leur monthly ou annual fee. Et donc, c'est juste une question de fee. Et je ne sais pas s'ils sont tombés d'accord sur le montant payé ou pas. Mais il y a d'autres alternatives qui sont là, disponibles à différents clubs.
Number 2.
Speaker, sir, the minister has already replied.
Next question.
B875, please.
Mr. Speaker, sir. I wish to apprise the House that I have been informed by the Mauritius Olympic Committee that it cannot disclose any information relating to both the financial assistance provided to athletes participating in the Tokyo Olympic Games and the provision of official outfit of the Mauritian delegation.
Bon, t'as terminé? Monsieur le Président, j'ai en ma possession une lettre du COM, Comité olympique mauricien, en date du 12 mai 2021, dans laquelle est indiqué qu'une somme totale de 900 000 roupies sera allouée à l'ensemble des athlètes mauriciens qui vont participer, et qui participent d'ailleurs, aux Jeux olympiques, et que la somme sera divisée équitablement entre eux. Et dans le cas d'un athlète en particulier, Jérémy Lara-Rodeuse, l'honorable ministre est-il en mesure de nous dire, il devrait le savoir, même si le COM n'a pas souhaité dévoiler certaines informations, que nous avons là, aujourd'hui, en notre possession, pourquoi il n'a reçu que 53 900 au lieu des 112 500 comme promis. Si on prend 900 000 qu'on divise par les 8 athlètes, je pense que c'est bien 8, l'honorable ministre peut nous le confirmer. Je pense qu'il y a un petit problème de comptabilité.
Monsieur le Président, d'abord, puisque l'honorable membre a soulevé la question de notre athlète Jérémy, qui était en action déjà aujourd'hui et au 110 mètres et donc qui a fait une performance de 14 secondes 03 centièmes, sa meilleure performance actuelle. Malheureusement, il est classé 7e et donc il n'est pas qualifié pour le prochain tour. Et je profite aussi de l'occasion pour féliciter toute la délégation mauricienne, tous nos athlètes, et je leur souhaite un très bon retour, safe return home, et bien sûr qu'ils vont commencer à se préparer pour d'autres compétitions. Monsieur le Président, si ce sont des montants alloués par le Comité olympique, malheureusement, moi, je n'ai pas en ma possession ces renseignements-là. Moi, j'ai les détails des fonds qui sont alloués par le ministère. Alors, les fonds alloués par la fédération, par le Mauritian Olympic Committee, malheureusement, je n'ai pas ces renseignements-là. Et je dois dire que le ministère n'a pas été informé officiellement aussi par la fédération ou par l'athlète lui-même. Donc, si éventuellement nous avons un courrier qui nous donne les détails de ce qui se passe, de la part de la fédération aussi, nous allons pouvoir nous entretenir avec le comité olympique.
Thank you. Honourable Minister, will you consider for a cash prize to be given to Mr. Mervaclair for his brilliant performance?
Non, Monsieur le Président, je crois que l'honorable membre se trompe totalement. Le cash prize qui est offert aux athlètes en général, que ce soit pour des compétitions régionales telles que les Jeux des îles, compétitions africaines, intercontinentales, mondiales ou olympiques, il y a des critères bien spécifiés et bien établis. Bien sûr, nous reconnaissons l'effort de tous les athlètes, parce que nous parlons des Jeux olympiques. C'est un très très haut niveau, que ce soit nos nageurs, nos athlètes, nos boxeurs, nous reconnaissons les efforts qu'ils ont faits et on va les encourager. Mervyn Claire est bénéficiaire du projet Paris 2024. Allons dire que Tokyo a été son entraînement pour éventuellement aller décrocher quelque chose lors des Jeux à Paris en 2024.
J'en ai deux, rapidement.
One last supplement.
Je as deux questions supplémentaires.
No, I don't mind if you have 10 questions. I'm giving you one.
Mr. Speaker, with my previous...
please.
Can I say something, please?
No, you don't have
with
to
my
say that.
previous speak.
No, and no. I'm giving you a last supplementary. That's all.
Monsieur le Président, je vais revenir à ma question initiale et je vais déposer une copie de la lettre du COM de façon à ce que l'honorable ministre puisse prendre connaissance. Alors, Concernant les habits officiels du Club Maurice pour les JO de Tokyo, le ministre peut-il nous dire s'il est informé que 2 membres de la délégation, encore une fois, le jeune Jérémy Lara-Rodeuse et son entraîneur Georges Vieillès, ont été privés de leur habit officiel par le comité olympique mauricien? Peut-on savoir pourquoi une telle démarche de la part du COM?
Monsieur le Président, encore une fois, malheureusement, je ne puis répondre pour le comité olympique. Et comme je l'ai dit précédemment, il n'y a aucune lettre, aucun courriel de la part de la fédération pour nous faire part du problème qu'a connu leur athlète et leur entraîneur. Éventuellement, je le redis, éventuellement, si au niveau de la fédération, il y a une requête officielle pour nous demander de faire une enquête et de voir avec le comité olympique pourquoi le cas que l'honorable membre a soulevé est arrivé, nous allons le faire. Mais il faut fonctionner d'après les formes qu'il faut, c'est-à-dire, bon, éventuellement, si la fédération prend contact avec nous, avec le ministère.
Thank you, Mr. Speaker, sir.
No.
B.
What point of order? You asked me. Vous m'aviez demandé si j'avais une autre question supplémentaire, une troisième question, j'ai dit non. Sur 2 questions. Sur ma dernière question, je vous demande de me permettre de poser une dernière question et vous refusez.
I have already ruled on that. You should understand. I have a role also in this chamber. You have your right, I have my right. I respect you and you have to respect me. And the matter is closed. Honorable Itu.
Merci, Monsieur le Président. B876. Thank you.
Mr. Speaker, sir, I'm informed by the Municipal Council of QP that the project construction of the new synthetic football pitch at La Pérouse has been completed on the 10th of October 2020 and handed over to the Municipal Council of QP on the same date. The inauguration was tentatively scheduled for the 6th of December 2020, but at the Council meeting of the 30th of November 2020, decision was taken to postpone all inauguration and reopening ceremonies for a later date in view of the prevailing sanitary condition. Mr. Speaker, sir, we are presently in the phase of deconfinement, when group sports are being allowed. In view thereof, all the local authorities have been advised to proceed by way of a soft opening of amenities so as to allow residents of the localities to benefit from the infrastructure put in place for sport, leisure, and recreation.
Supplementary.
Thank you. Can we know from the Honorable Vice Prime Minister whether for this particular project was there any collaboration or coordination with the other ministries, since I understand it is in the same compound as the La Pérouse Community Center, falling under the Sugar Industry Labour Welfare Fund, actually sharing the same entrance?
I mean, as far as decision was taken for group sports, that was not allowed at that time. But now the decision has been taken to allow group sports, so that's why you're opening now.
Next question.
B877.
Mr. Speaker, sir, in reply to Parliamentary question B751, I had informed the House that there were constant acts of vandalism at La Tour-Koenig and Consaplon Football Ground in constituency number 1, Grande Rivière Nord-Ouest and Port-Louis West, and the Municipal Council of Port-Louis was undertaking repairs at the 2 football grounds. I'm informed by the Municipal Councils of Port-Louis that La Tour-Koenig Football Ground, at La Tour-Koenig Football Ground, the lighting as well as the irrigation system, which has been newly installed in June 2021, have been damaged in July 2021. The cost estimate of the repairs are being worked out, and the work are expected to start in the 2nd week of August 2021. With regard to Consaplon Football Ground, the water meter has been stolen and part of the fencing has been damaged. A complaint was lodged at the police by the Municipal Council of Port-Louis on the 26th of July 2021. Consequently, the Central Water Authority has been requested to install a new meter, and the Council would start the repairs of the fence in the 2nd week of August this year. The Municipal Council of Port-Louis has also apprised my ministry that the lighting system at Freddie Defoe Football Ground at Cassie has been damaged by vandal on the 25th of July 2021. A survey on the extent of damage has already been carried out and the scope of work is being worked out. Mr. Speaker, sir, with regard to part B of the question, I'm informed that the ward councillors have been requested to sensitize the inhabitants and the users to make judicious use of these facilities and not to commit acts of vandalism. In addition, the Municipal Council of Port Louis will be requested to liaise with the local police for regular patrolling in the concerned areas, especially during off-peak hours. The Municipal City Council of Port Louis, Mr. Speaker, sir, is also ensuring that these facilities and social amenities are operated during a certain period of time during the day and are closed and locked at night for security reasons, so as to limit acts of vandalism thereat. As a matter of fact, it has been noticed that such acts of vandalism are occurring too frequently, and consideration is being given for the installation of CCTV camera on the premises of these amenities. Mr. Speaker, sir, the House would appreciate that the government is implementing many projects in terms of social amenities and facilities to enhance the social well-being of the population. And it is the responsibility of the public also to make good use of these facilities and keep them in good state for their own convenience. Another example I was going to ask for the Grande Rivière Northwest Football Ground, the main switch panel, which was repaired in June this year, has been damaged again on Sunday, that is 3 days ago, on Sunday, the 1st of August, Mr. Speaker.
What is happening?
Merci, Monsieur le Président. Puis-je savoir du vice-premier ministre, parce que vous avez mentionné la présence de caméras de CFCT, combien de terrains de foot municipaux dans la circonscription numéro 1 sont en réalité couverts par les caméras de CFCT et si des images ont pu être visionnées dans le cadre d'enquêtes policières afin d'identifier les auteurs de ces actes répétés de vandalisme.
No, I've not said that they have it now. I said consideration is being given for the installation of CCTV. So we are considering to put CCTV installation now.
Honourable Armand.
Thank you, Mr. Speaker. One of the recurrent problems of robbery concerns the electrical panel. The Minister just mentioned it. Can I ask the Minister whether he's going to have a look at placing a safer electrical cubicle to prevent such occurrence in the future? Because every time it's been changed, I agree with him, June, July, but we have to find a way to have a proper electrical cubicle to prevent this robbery. Can we please look into the matter?
Mr. Speaker, sir, look, I think the Municipal Council is providing these facilities. I mean, we have to be fair to the Council as well. They're providing, I think the people who are using it must make good use of these facilities. I answered this question, a similar question about 2 weeks ago on vandalism in the same constituency. And now, 2 weeks later, now 4 football pitch has been damaged. I think people would have to take their responsibility. The Municipal Council is doing the repair. Now we contact the police. We're trying to sensitize the inhabitant. And we are trying to, now we are going to consider putting CCTV as well, camera. We are doing our best. But I think the people in the constituency to take their responsibility as well.
Last supplementary.
Merci, Monsieur le Président. Je comprends la réaction du vice-premier ministre. Sachez que les habitants de ces régions, et notamment les jeunes qui nous regardent, sont les premières victimes de ces actes de vandalisme. En attendant qu'il y ait de la technologie qui puisse assurer la sécurité de ces terrains de foot, le vice-premier ministre peut-il nous dire s'il pourrait y avoir une considération pour retourner à l'ancienne bonne vieille méthode d'un gardien de nuit pour pouvoir verrouiller ces terrains de foot, cadenasser et les sécuriser. Je comprends qu'il y a donc des dépenses qui sont faites pour réparer systématiquement les dommages. Est-ce que ce même budget ne pourrait pas servir à rémunérer certains gardiens de nuit?
Mr. Speaker, we have about 100 amenities, such amenities in the city of Port Louis. If I'm going to get security facilities for 100 amenities, and you can imagine how much that's going to cost the council. But I appreciate for the young people, for the other young people who are innocent, who are being deprived of these facilities. I do share that concern as well. And that's why the municipality is going to put, okay, we are going to try to find somebody to lock this place at night, and we are going to try to put CCTV camera gradually. I'm not going to say we are going to put in all of them, all 100 of them instantly, but gradually we are going to do so.
Honorable Lobien.
B878, please. Mr. Speaker, sir, I wish to inform the House that no official complaints have been received by my ministry from the Public Health Services staff to the effect that they are overstretched and overworked. Following the outbreak of COVID-19, medical and paramedical staff are redeployed and posted in quarantine and treatment centers, as well as in the contact tracing and the vaccination teams. The unprecedented COVID-19 situation led the medical and paramedical staff, including the lab services, to perform extra duties, and I wish to seize the opportunity to commend them for their dedication. Mr. Speaker, sir, since the outbreak, the Ministry put in place the following measures to ensure a fair work distribution by involving staff from each of the five regional, each of the five national health regions. A national roster was implemented to cover for staff requirements in quarantine centers, treatment centers, contact tracing teams, COVID-19 testing centers, and in our medical unit set up at the level of the port and the airport. 285 doctors have been enlisted to provide additional manpower to meet with the redeployment of staff. 50 retired nurses were employed on a sessional basis. As at date, 43 of them are still in service. In addition, 7 nursing officers have been employed on a contract basis for a period of 6 months since March 2021. The House will also note that 40 candidates have been offered employment as nursing officer on a month-to-month basis, and they will assume duty in our regional hospital as from tomorrow, the 4th August 2021. Provision was made for an allocation of bank sessions to ensure adequate staffing as and when required.
Thank you, Mr. Speaker, sir. Has the Honourable Minister taken cognizance of the difficulties faced by the employees of the public health, as pointed out by Mr. A.S., the President of the Ministry of Health Employees Union? And it was recently in the press when they went for a press conference elaborating all the difficulties being faced specifically by the nursing officers working within the public health sector.
Mr. Speaker, sir, yes, the Ministry is aware of we have already given them an appointment, and all those issues have already been dealt.
Is the Honourable Minister aware as to the difficulties being faced by specifically employees working at Mocha Hospital with regards to lack of social distancing, lack of hygiene, and lack of equipment for them to work properly? Is the Honourable Minister aware of that situation?
Mr. Speaker, sir, yes, at the Mocha Eye Hospital there is a spacing problem. That's why the government is coming with the new Mocha Eye Hospital. But at the same time, there is no lack of equipment or hygiene at the hospital. There is supervision regularly by the different authorities, and these issues are being dealt on a weekly basis.
Move to your next question.
B879, please.
Mr. Speaker, sir, I'm informed by the Municipal Council of Vakwa Phoenix that a portion of land vested with the Council was put at the disposal of the Vakwa Phoenix Swimming Pool Foundation through a Memorandum of Understanding for the construction and management of a swimming pool and other associated amenities thereat. The representative of the Vakwa Phoenix Swimming Pool Foundation includes, among others, the Emirates Airline, which has provided funds to the tune of USD 6 million USD thereto for construction and maintenance of the swimming pool. I'm also informed by the Municipal Council of Vakwa Phoenix that the construction work of the swimming pool and its amenities have been completed, and the site handed back to the Vakwa Phoenix Swimming Pool Foundation on the 18th of June 2021. Mr. Speaker, sir, the Vakwa Phoenix Swimming Pool Foundation has been registered as a charitable foundation on the 9th of January 2019 under the Foundation Act 2012. As such, the foundation has a separate legal personality and it is managed by council in accordance with the provision of that act, which include non-disclosure of confidential information. In view thereof, I'm not in a position to provide to the House any detail as to the management of the affairs of Vakwa Phoenix Swimming Pool Foundation, nor to communicate the expected date of coming into operation of the facilities or any fees that will be charged.
Thank you, Mr. Speaker, sir. May I know from the Honorable Vice Prime Minister, who is maintaining and managing that swimming pool? Is it the Vakwa Phoenix Swimming Pool Foundation or the newly government-owned company Vakwa Phoenix Sports Infrastructure Company Limited?
It is a foundation that has administrative council which is going to run it.
May I further ask the Honorable Vice Prime Minister to verify that questionnaires and application forms are being delivered under the caption Vakwa Phoenix Sports Infrastructure Company Limited? Can he inform?
I'll check onto that, but I know it's the council that is. I'll check on that, but I know it's the council that is looking after that.
Thank you.
Last supplementary.
Monsieur le vice-premier ministre, nous parlons bien du Emirates Airlines Swimming Pool?
Yeah.
C'est de ça. Vous êtes sûrement au courant, monsieur le vice-premier ministre, que l'initiateur de ce projet fut l'ancien ministre Shaukat Ali Soudan. C'est lui qui fut, il faut bien le dire, à la base de ce projet. Et quand il avait présenté ce projet, monsieur le vice-premier ministre, il avait parlé aux habitants de la circonscription numéro 15, surtout de Vakwa, pour dire que cette piscine, ce swimming pool, sera gratuit. Il n'avait rien payé, c'était un don de l'étranger. Aujourd'hui, les gens de la ville de numéro 15 nous posent des questions, justement, et ma question est la suivante. Comment est-ce possible aujourd'hui, monsieur le vice-premier ministre, que vous faites payer, la municipalité de Vakwa Phoenix va faire payer aux habitants pour utiliser cette piscine, alors que l'ancien ministre avait dit que ce sera gratuit?
No, I don't think it's right what you're saying. It's not Vakwa Phoenix, municipality of Vakwa Phoenix, that's getting the people to pay. I think you have to be fair and to be accurate in what we are saying. It's a foundation. There has been an MOU with a foundation which has financed this project, and they're going to decide whether it's going to be free or going to be paid. That's what they're going to decide. So it's not fair to say that Vakwa Phoenix Council is getting the people to pay.
No question now.
B880.
Order. No conversation.
Mr. Speaker, sir, I am informed by the Central Electricity Board that CB FiberNet Company Limited has a control center, also called a Network Operation Center, NOC, in its Vakwa office. The Network Operation Center consists of a server called the Network Management System, which displays all the links in the CB FiberNet national backbone and logs any faults on the network on a 24/7 basis. Mr. Speaker, sir, I'm further informed that a managed service contract was signed in 2018 with ECI Telecom, subsequently acquired by Ribbon Communication, a US-based organization, where one of the latter's main responsibilities is fault management on a 24/7 basis. Under this managed service contract, the Network Operations Center is manned during working hours by an engineer from Ribbon Communication, who actively monitors the network and provisions new circuits. After working hours, the NOC equipment is managed remotely by Ribbon Communication Global Services Center, located out of the country. As such, Mr. Speaker, sir, the CB FiberNet Company Limited does not employ any engineer at the Network Operation Center. The engineers posted there are employed by Ribbon Communication. Thank you, Mr. Speaker, sir.
Et, Monsieur le ministre, si j'ai bien pu comprendre, le ECI, donc la firme initialement israélienne, qui aujourd'hui gère notre control center, et vous dites, si j'ai bien compris, ce control center, en dehors des heures normales, ce control center est géré en dehors du pays. D'où vous voulez dire? De quelle station est géré ce control center si ce n'est pas à l'île Maurice?
I understand from the Central Electricity Board, Mr. Speaker, that after working hours, the NOC equipment is managed remotely from Mumbai, India.
You address the question to the minister, but through me. No, you don't need, but you should know how to ask a question, please. Please.
Monsieur le ministre, en vous regardant, Monsieur le Président.
No. I stop your question and I move to the next question. Honorable Dulab. Honorable Dulab.
B882.
Honorable Kalichan.
Mr. Speaker, sir, in order to restore the purchasing power of consumers, government has decided to bring some essential and widely consumed products under the price control by fixing their prices for a 6-month period, both in Mauritius and Rodrigues. In the endeavor to protect the consumers, the government ensured that importers, distributors, and retailers do not bear the brunt of this measure. As a result, this government is providing a subsidy to the importers and distributors through the Mauritius Revenue Authority. This price control measure is estimated to cost around 500 million rupees and will be fully funded by the government. Mr. Speaker, sir, as regards to the first part of the question, officers of the Consumer Affairs Unit of my ministry are effecting daily visits to trade premises and are inspecting supermarket, hypermarket, shop, and warehouses. The products under price control are available on the local market and no shortage is foreseen. As regards to the second part of the question, I am informed that the Ministry of Finance, Planning and Economic Development has entrusted the MRA the responsibility for the payment of subsidy on the above-mentioned essential goods. In order to benefit from the payment of subsidy on essential goods, a two-staged process has been put in place. All eligible traders will have to be registered with the MRA and secondly make an application for payment of subsidy. Several meetings were held with the Ministry of Finance, Economic Development Planning and the MRA and the Mauritius Chamber of Commerce and Industry. Following discussions, consensus was reached that subsidy will be payable to any registered licensed importer, manufacturer, wholesaler, or distributor who sells directly to a retailer and also to any registered licensed importer or manufacturer who also holds a license for general retailer and sells the 7 commodities directly to members of the general public. In addition, the MRA has also made arrangements for any licensed retailer who still had in his possession a remaining stock of the 7 commodities as at
12th of July 2021 to apply for the subsidy only for the month of July 2021. As at 29th of July 2021, 14 eligible traders have been registered under this scheme. With respect to payment of subsidy, the eligible traders shall be able to make the application as from 2nd of August 2021. The Consumer Affairs Unit has effected 1,435 visits and issued a total of 119 contraventions as at 29th of July. These contraventions include offences where traders did not affix properly the prices of products and where they were practicing a price which is higher than that fixed by the government. No case of hoarding has been found, and therefore no trader has been contravened for same.
Thank you, Mr. Speaker, sir. The new subsidized prices were to be effective as from 12th of July 2021. Suppliers, importers, or distributors already had a stock at that time. Can the Minister inform the House as what would be the mechanism or modus operandi with regards to payment of subsidies on stock level held by suppliers or importers?
Well, Mr. Speaker, sir, for the first disbursement, which will essentially consist of supplier stock, at 12th of July 2021, ledgers will be examined on a case-to-case basis. The MRA will also work essentially on the determined and confirmed stock levels and will refund accordingly to supermarkets and hypermarkets. As regard to small shops, retail outlets, which do not have an online system and are not yet connected with the MRA, the MRA will apply a risk assessment formula. And I must confirm, Mr. Speaker, sir, that the refund for payment for stocks before coming in force of this regulation will be an one-off payment.
Thank you, Mr. Speaker. So in his reply, the Minister just mentioned a total of 119 contraventions. Can he inform the House as to what does the law provides for those contravening, more specifically, selling at a higher price than recommended?
Mr. Speaker, sir, the Consumer Protection Price and Supply Control Act, under which regulation is made, provides for a person may not sell or supply an essential good at a price lower than its maximum price. And no person shall sell or supply an essential good at a price exceeding its maximum price. Therefore, any person who contravenes these two sections, they will commit an offense and on conviction will be liable to a fine. That is not less than 75,000 rupees and not exceeding 100,000 rupees. So traders must comply with the law, otherwise they will be called to pay excessive fines.
Last supplementary.
Thank you, Mr. Speaker, sir. I refer to the period prior to 12 July 2021. Retailers, especially from the modern trade meaning hypermarket and supermarket, would offer promotional offers, prices on almost all basic items, and what is referred to as on fast-moving goods. From my information gathered, it appears that there are retailers who are no longer offering promotional offers on subsidized items, thus leaving the and consumer being penalized. Government has put up means to alleviate the less fortunate ones. Can the Honourable Minister please look into this practice?
Mr. Speaker, sir, right from the beginning, my ministry made it clear that specific promotions should continue. Unfortunately, the ministry have noted that promotions are being held, but not on the scale and magnitude as it used to be held. Therefore, my ministry will ask MCCI to talk to its members to resume promotions. Otherwise, in the event they do not comply, we will have to take a further step, that is to reduce the price.
Next question.
Merci, Monsieur le Président. B883.
Mr. Speaker, sir, as announced in the budget 2021-2022, government has made provision for the issue of 500 new fisher cards to applicant artisanal fishers. This decision clearly indicates the economic importance of the off-lagoon artisanal fisheries sector and especially its contribution to food security. Mr. Speaker, sir, a technical committee has been set up to look into the revision of policy regarding the new condition for the registration of fishers. With your permission, I'm tabling the revised policy. Mr. Speaker, sir, priority of consideration is being given to applicant fishers who have been waiting for the last 10 years. They have been monitored to ascertain the genuineness in fishing activities. Out of 725 applicants, 487 have been found to be neither in gainful employment nor holder of a trade license. They have been shortlisted and same has been sent to the Ministry of Health and Wellness to arrange for them to undergo a medical examination. Simultaneously, the applicants have been requested to submit a character certificate and a recommendation letter from the registered fishers in whose boat they are engaged, certifying that they are actively involved in off-lagoon fishing activities. Thereafter, all the applicants who have fulfilled the selection criteria will have to follow the general fisher course to be registered as fishers. The theoretical training courses will be jointly organized by the Fisheries Training and Extension Center and the Mauritius Maritime Training Academy, while for the practical session around the fish aggregating devices, the collaboration of local offshore fishing vessels will be enlisted in view of limited capacity available at my ministry to ensure a higher intake. The course will include modules relating to safety at sea, fishing techniques, communication, mounting of gears, outboard engines, and practical at sea. The intake of trainees for the general fisher course would be increased such that 5 batches are run in parallel, each batch following a different module to ensure that a cycle of 6 weeks generates 120 trainees. The course is intended to start as from 1st of September 2021. All going well, the training program would end by March 2022. Thereafter, a screening of new applicants will be effected and training would continue until all eligible applicants obtain their fisher cards.
Merci, Monsieur le Président. Le ministre peut-il informer la Chambre s'il est en présence d'une lettre émanant du syndicat des pêcheurs en date du 21 juillet concernant justement l'éventuelle allocation des cartes de pêche et aussi également l'exemption du certificate of character concernant les pêcheurs éligibles.
Yes, Mr. Speaker, sir, as rightly pointed out, I have received representation from Ms. Aurel, syndicat des pêcheurs et comité conjoint pêcheurs sans code, régional la Ligue, le Sud, I quote, depriving people, I quote Ms. Aurel, depriving people of means for a living after they have done their sentence is a punitive measure. It amounts to a lifelong sentence. The technical committee of my ministry has indeed given due consideration to this issue, except those convicted for drug trafficking or peddling will be disqualified.
Est-ce que le ministre peut-il nous dire s'il compte rencontrer les représentants de ce syndicat des pêcheurs pour en discuter plus longuement, s'il vous plaît? Merci.
Mr. Speaker, sir, I'm meeting the representative on Thursday.
Next question.
B885.
Mr. Speaker, sir, a system for online teaching and learning has been put in place by my ministry to dispense education in case of school closure. The House may wish to know that online classes were conducted between the 21st of June 2021 to 2nd July 2021 for grades 10 to 13, while pupils for grades 1 to 9, relevant educational programs were broadcast on the national TV. Schools were required to monitor the attendance of students for these online classes, and heads of schools had to inform parents in case students did not attend to find out why they did not. After the resumption of studies on the 5th July 2021, a few areas were declared red zones leading to school closure in these zones. Remote classes were conducted for students of these schools. Similar measures were taken for schools where COVID-19 positive cases were detected and which were closed temporarily for disinfection purposes. Mr. Speaker, sir, as announced in my reply to parliamentary question B648, we already have an e-learning platform, and my ministry intends to come up with a more sophisticated one in the future. The ministry is presently working in collaboration with the Mauritius Institute of Education on a pilot project, the virtual classroom, which will allow a blended mode of teaching and learning, and that is a mix of face-to-face and online learning.
Président, merci. La ministre peut-elle assurer à la Chambre que toute décision prise autour de la question de e-learning, etc., et la présence des élèves, le fait que les élèves puissent suivre les cours, est-ce que toute décision aurait pu être prise en consultation avec les différents partenaires de l'éducation et que no one is left behind?
Mr. Speaker, sir, in the question that I replied a few minutes back, I just mentioned that a committee has already been set up at the level of the ministry to discuss with all stakeholders regarding any measures we're going to take in cases online teaching will be required.
Les différents stakeholders concernent le corps enseignant.
Certainement.
Et les parents également. Est-ce que les parents sont consultés sur le sujet?
Monsieur le Président, nous avons un travail à faire au niveau du ministère pour décider de la façon de dispenser les cours au cas de school closure. Bien sûr, quand il faut parler aux parents, à travers les PTA, cela se fait au niveau du ministère.
Madame Bélanger.
B890.
Monsieur le Président, dans ma réponse à la question parlementaire B597, j'ai souligné que la route B du Cap Chamarel-Casnoyal, B104, se caractérise par une étroite chaussée unique à 2 voies et que l'itinéraire comportait plusieurs virages dangereux avec des coupées abruptes de montagnes d'un côté et de profonds ravins de l'autre. L'état de la structure de la chaussée et le support géotechnique sous-jacent était tel qu'une intervention urgente pour empêcher le glissement de terrain et pour la stabilité des pentes était nécessaire. Je comprends que mon ministère est bien en présence d'une lettre datée du 5 avril 2021 du président de la Royal Society of Arts and Science, avec copie au ministère de l'Infrastructure publique et au ministère de l'Agro-Industrie, entre autres, évoquant des préoccupations et des représentations sur l'abattage d'arbres le long de la route B104. Par la suite, l'attention de la RDA a été officiellement attirée sur les plaintes concernant le projet. Monsieur le Président, dans ma réponse à la PQ B597, j'ai souligné que l'amélioration de la route n'est en fait pas a schedule activity, nécessitant un Environmental Impact Assessment License, conformément à la partie B du 5th Schedule du Environment Protection Act de 2002. Cependant, dans le cadre de sa mission concernant la route B104, le consul limité a préparé un rapport d'évaluation environnementale. Le dit rapport a souligné la nécessité de préserver les arbres endémiques situés à proximité de la route et a recommandé des mesures pour éviter les dommages directs ou indirects à ces arbres lors de la préparation du site et de la construction. On me fait comprendre que le service forestier a autorisé l'abattage d'arbres situés sur le tracé proposé et où des travaux de stabilisation des pentes étaient requis le long de la route B104 à Chamarel, sous réserve de conditions. En conséquence, la RDA a été priée d'assurer l'arrachage soigneux de tous les arbres endémiques qui seraient affectés et leur retransplantation. Sinu Hydro Corporation Limited, l'entrepreneur, a également été sollicité pour déplacer les plantes du site vers le Stateland Bimanic à la Nouvelle-France, sur une superficie de 2 hectares. Cet exercice est en cours depuis le 7 juin 2021 et fait l'objet d'un suivi quotidien par les agents forestiers. Tous les efforts sont faits pour épargner un maximum d'arbres sur le site. Dans le cadre des conditions, la RDA a également été priée de faire planter 3 fois le nombre d'arbres endémiques qui seraient abattus et de les maintenir pendant au moins 2 ans jusqu'à ce qu'ils soient bien établis. Je suis informé qu'au 30 juillet 2021, 377 plantes endémiques avaient déjà été transplantées sur le dit site et que 623 nouveaux arbres ont été plantés sur le même site. Monsieur le Président, la RDA a donné l'assurance que les travaux de réhabilitation sont effectués conformément au rapport d'évaluation environnementale de Luxe-Consul Limité et que toutes les mesures nécessaires qui ont été recommandées pour atténuer les impacts négatifs sur l'environnement et protéger les plantes endémiques qui sont près de la zone du projet sont entreprises par Sinu Hydro Corporation Limited. Je suis informé qu'un plan de surveillance environnementale a été préparé par l'entrepreneur à cet effet. De plus, Sinu Hydro Corporation Limited a embauché les services d'un ingénieur en environnement pour le suivi de toutes les questions environnementales, et ce, en étroite collaboration avec les ingénieurs de la RDA. Monsieur le Président, la faune et la faune du site sont ainsi protégées et tous les membres de l'effectif de l'entrepreneur ont été sensibilisés quant à la nécessité de la préservation de la biodiversité sur place. Dans le cas où une zone au-delà des limites est perturbée pendant la mise en œuvre du projet, l'entrepreneur rétablira le sol et restaurera la végétation appropriée selon les directives de l'ingénieur de l'environnement.
Merci, Monsieur le Président. Je suis très étonnée du terme utilisé par le ministre, un abattage soyeux, alors que j'avais déposé sur la table de l'Assemblée les photos de la barbarie avec laquelle plus d'une trentaine d'arbres endémiques avaient été coupés. The Environment Protection Act states clearly in Schedule 6 Part B that conversion of forest to another land use, this is Section 10, and at Section 24, projects which is undertaken on mountain slopes or undertakings requiring an environmental impact assessment. So can the Minister state why no environmental impact assessment has been carried out, although it is required by law?
Monsieur le Président, je pense avoir répondu à la question. Et cette question a fait l'objet de plusieurs questions semblables dans le passé, adressées à moi-même, adressées à mon collègue du ministère des Infrastructures publiques, d'autres collègues ministres. Moi, je pense que cela a été très clair, Monsieur le Président, vu les impératifs en ce qui concerne l'urgence de la construction des routes sur place, les dispositions qui ont été prises par le Ministry of responsable du Forestry et la RDA, le consultant qui est responsable sur place, le Luxe-Consul Limité, conjointement avec le contracteur, Monsieur le Président, toutes les dispositions sont prises pour la préservation de la faune et la flore sur place. Monsieur le Président, je maintiens ma réponse telle que je l'ai mentionnée pour dire que les travaux entrepris ne sont pas considérés comme a scheduled activity selon le Environment Protection Act.
The table has been advised that PQ B894, B895, and B896 have been withdrawn. Time over.
Motion.
Mr. Speaker, sir, I move that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10.
Seconded. The question is that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10. Those in favor say aye, those against say no. Ayes have it.
Statements by ministers none. Public bill, second reading.
Public bill, second reading.
Yes, Mr. Speaker. The Finance Bill covers an array of amendments to various pieces of legislation to provide for implementation of measures announced in the budget speech 2021-2022 and for matters connected, consequential and incidental thereto.
Order. Order. Minister, continue.
Yes, it might.
Order.
It might be apposite to note, Mr. Speaker, sir, that respect for parliamentary traditions is a two-way process. Just as for government and for the majority in Parliament, it is our duty to listen to the opposition, to take into account proposals, criticism made,
Order.
Whereas it is the duty of ministers to respond to questions and answer all questions. It is the duty of ministers, and I'm speaking for the public outside viewing these images on television, it is the duty of ministers to stay here in the early hours of the morning to listen to all the matters raised at adjournment and to respond thereto. It is also equally the duty of the opposition not only to hit at government, but to listen to the explanation offered, to the explanation as to legislation which is before this House, and to partake in the business of debating and enacting legislation. All too often, and we do applaud Honourable Abbas Mahmoud. I was saying that as we intervene at the end of the debate on the Finance Bill, we once again respond to points made by the opposition and explain the proposal of government. And it is a matter of utter dismay that the opposition once again, having had its say and having been listened to by government, not to be here, not to do its duty for which it is paid from public funds, to represent all of our people and to pay respect to the traditions of parliamentary democracy. But be that as it may, government business has to go on, and we shall do our duty in intervening to conclude the debates on the Finance Bill. Mr. Speaker, I do not propose to be long. It is not my intention to repeat the debate on the budget, nor to repeat what has been said before by other members. I will therefore briefly refer to the clauses of the Finance Bill that pertain to my area of responsibility: tourism, housing and land use planning. I shall first consider the clauses of the finance bill that pertain to the tourism sector to briefly explain what government is doing through the finance bill. Firstly, Mr. Speaker, clause 22 of the finance bill relates to the EDB Act, amends the EDB Act by introducing a new section 13, subparagraph 4, whereby applications for occupation permits will henceforth have a time limit of 5 days. Whenever a ministry, let us say the Ministry of Tourism, is consulted on an application for an occupation permit that is being piloted by the EDB, if within 5 days no reply is obtained, it shall be considered that the Ministry of Tourism is not objecting. This is a most welcome innovation because the contribution of foreign expertise, of foreign skills to the development of the tourism sector has been of critical importance throughout the history of tourism. And the amendment being brought by my colleague, the Minister of Finance, eloquently states the principle that henceforth we should be expeditious in addressing the request for foreign expertise as proposed by the EDB. The other clause pertaining to tourism is clause 44 of the finance bill that relates to the Land Duties and Taxes Act. Now, members of the House will have noted that henceforth the tax on transfer of leasehold rights, which is dealt with under section 45A of the Land Duties and Taxes Act and the 7th schedule of the Act, relates to the rate of tax on transfer of leasehold rights, and what is being proposed is to halve the rate of tax, so that instead of the current tax rate of 20% being paid equally by the buyer 10% and the seller 10%, the rate is now being reduced to 5% each. Now, this change is to be understood within the perspective of government's policy to fight the impact of the COVID on our economy by supporting economic firms and enterprises in order to protect jobs and safeguard livelihoods. What is being facilitated through this amendment to the legislation is that when and where it is necessary to transfer leasehold rights, having regard to hotels, this can be done at lesser cost to the enterprises, to the investors involved, in order to safeguard jobs and livelihoods. Another interesting amendment being brought is that embodied in clause 48 of the Finance Bill that relates to the Local Government Act. And this is at the initiative of the EDB. And if you will bear with me, Mr. Speaker, so I will very briefly explain what we are about here. Now, actually, at present, tourism operators are exempted from payment of trade fees to local authorities because they are regulated by the tourism authority, and they already pay license fees to the tourism authority. This was an old administrative arrangement with the local authorities. However, when collection of trade fees was transferred to the Central Business Registration Department under the Minister of Finance, there were certain issues in terms of businesses that were exempted or not from payment of trade fees. For instance, the tourism accommodation certificate caters for services like beauty parlors, health and fitness, spa and wellness, supply and sale of liquor, shops, boutiques, bars, owned by the same operators as listed by the Tourism Authority. But these operators, in effect, were being asked to pay trade fees, whereas they were also paying Tourism Authority licenses. Now, as it has been announced by the Minister of Finance in the budget speech, henceforth trade fees will not be applicable to any person, to any firm holding a tourist enterprise license. Consequently, what Clause 48 of the Finance Bill does is to amend the 12th schedule of the Local Government Act to list activities that are exempted from payment of trade fees to include any holder of a certificate license or permit issued by the Tourism Authority. Next, Clause 85 of the Finance Bill deals with an amendment to the State Land Act. In this case, you may recall, Mr. Speaker, sir, that last year, rental payments for industrial leases of state lands for tourist-related activities was waived completely. This year, what is being proposed in the Finance Bill is that rather than having to pay in advance by 31st of July, payments will be effected at the end of the fiscal year. Now, this is of critical importance to help the resumption of activities within the tourism sector. Right now, I am happy to report to the House that more than 50% of our hotels are in operation. If not as quarantine or treatment centers, then again as resort hotels or as establishments open to the locals for local tourism. Guest houses are gradually picking up. Since the 23rd of July, a large number have gone back into operation, and this legislative proposal will go a long way in assisting tourism enterprises to get on their feet again and start operating normally. The final point regarding tourism relates to Clause 37 of the Finance Bill, which amends the Immigration Act, Section 2 of the Immigration Act, the definition section, to provide a definition for the Invest Hotel scheme. What is being proposed is that under that scheme, for which the EDB makes specific regulations, henceforth, sale of up to 80% of the units of a new, let us say, hotel complex will be allowed, with the possibility for the owner of the room to stay for a maximum of 6 months, as opposed to 45 days, which it was previously since 2015. Now, I had proposed to respond to the very harsh criticism of the leader of the opposition, having regard to the Invest Hotel scheme, but I do no longer propose to do so in his absence. I believe the matter is largely irrelevant, since nobody else has raised the criticisms that he aired in the House and which we patiently listened to and prepared to respond to. I shall therefore move on straight to the housing sector. Now, in the housing sector, Clause 22 of the Finance Bill amends the EDB Act to provide for the Ministry of Housing and Land Use Planning, together with the Prime Minister's Office and the Ministry of Finance, I believe, to have a specific representation on the board of the EDB, which is all too logical, being given the requirements of development in our day and time, so I won't delve any longer on that issue. But Clause 45 brings a very important amendment to the Landlord and Tenant Act. You may recall, Mr. Speaker, that last year, in the COVID-19 Act, the Landlord and Tenant Act was amended so that persons who were not able to pay their rent between March 2020, when the first confinement intervened, the first lockdown in fact, up until August 2020, were no longer at risk of an eviction order. Non-payment of rent during that time, according to the amendment brought by government in 2020, was not considered a breach of the tenancy agreement, and a moratorium was provided for in the sense that tenants could pay the unpaid rent by installments up to 31st of December 2021. Now, this provided enormous relief to a large number of small tenants, but did give rise to some abuse. So this year, while hastening to act once again to protect small tenants from the hardship caused by the COVID confinement period, the proposal of government has been modified to a certain extent. Once again, non-payment of rent for the months of March 2021 to August 2021, I'm referring to non-payment of rent for premises, of course, will not constitute a breach of a tenancy agreement, will not automatically entitle the owner to an eviction order, but the rent will have to be repaid. This time, half of it will have to be repaid by the end of December 2021, and the balance to be paid in 12 equal monthly installments between January and December 2022. Mr. Speaker, the Finance Bill also amends the Morcellement Act to provide for the Land Drainage Authority to be henceforth represented on the Morcellement Board, for the simple reason that we know one of the major challenges facing us is that brought about by climate change and the extent of unusual rainfall and the flooding that this implies. The Land Drainage Authority came into operation only 3 years ago, and government feels it is critical at this point that the Land Drainage Authority be fully party to the process of awarding a morcellement permit to any prospective developer. And finally, and this will be my last point, Mr. Speaker, Clause 75 of the Finance Bill amends the Real Estate Agent Authority Act. Now, this is in line with the good work being undertaken by my colleague, the Minister for Financial Services, within the perspective of the fight against money laundering, so that henceforth any person registering as a real estate agent with the Real Estate Agent Authority will have to register with the Financial Intelligence Unit, the FIU, within a delay of 5 working days of his registration as real estate agent, in compliance with Section 14C of the FIAMLA, which states that every reporting person or auditor shall, within such time and in such form and manner as may be prescribed, register with the FIU. So the proposed amendment aims at classifying promoters, land promoters and developers as reporting persons under the FIAMLA, whether they act for a client or not, or in their own capacity, to ensure further compliance with recommended international best practices and norms for combating money laundering and the financing of terrorism and proliferation. Mr. Speaker, I thank you for bearing with me through these technical explanations of what is being proposed, and I will end by inviting all the members of the House to support the proposals in the Finance Bill as introduced by my colleague, the Minister of Finance. Thank you, Mr. Speaker.
Monsieur le Président, tout d'abord, je me joins aux remarques du Deputy Prime Minister pour que le public puisse voir. J'espère que le Parlement TV peut montrer les bancs vides de l'opposition. Comme toujours, ça devient une habitude, à l'exception de l'honorable, toujours, de l'honorable Salim Abbas Mahmoud. Donc je ne vais pas répéter ce que le DPM a dit. Mais moi, par contre, j'ai l'intention de faire mon discours comme j'avais prévu, et peut-être même je serai inspiré de dire certaines choses. En plus, on verra en cours de route. Mr. Speaker, sir, every year the Finance Miscellaneous Provisions Bill is presented by the Minister of Finance, and normally a few weeks after the appropriation bill is voted by the National Assembly. And every time, I've been looking at the previous bills, every time, I must say, it has been a voluminous bill with amendments to numerous acts of Parliament, as the measures announced in the budget, they cut across many sectors, and they impact on many government departments and public entities. And this year is, in fact, it is not only no exception, it goes even further. The finance bill, I must say, is more voluminous, as the challenges faced by the country are multifold and multisectoral, and are compounded by the adverse impact of the COVID-19 pandemic. Therefore, Mr. Speaker, sir, I believe that Honorable Utim of the MMM should have refrained from saying that we have buried so many amendments to so many acts in a 300-page document. This is again, once more, utter demagogy, as usual from the Honourable Member, and I wanted at the very outset to denounce that sort of very cheap argument. Having said so, Mr. Speaker, sir, the number of legislations being amended through the Finance Miscellaneous Provisions Bill testifies that we are adapting our legislative framework to better respond to current realities and challenges. Since honourable members on this side of the House have abundantly dealt with many of the proposed amendments, I will also focus my comments on a few of them, of which, of course, some are related to legislations that govern departments and entities falling under my portfolio of responsibilities. Mr. Speaker, sir, Budget 2021-2022 paved the way to reverse the economic downfall due to the COVID-19 pandemic, build resilience, and prepare our economy to leap back into the league of high-income countries. Measures announced emphasize on sustainability and inclusiveness of growth. And for that to happen, there was the need to put in place all legal, administrative, and fiscal instruments to instill confidence, rekindle investment, boost exports, increase competitiveness, and create the right environment for a culture of integrity and excellence to percolate across all sectors. And that is what the provisions of the Finance Miscellaneous Provisions Bill 2021 aim at. In view of the very challenging context, we need to pursue with reforms to enhance further our ease of doing business regime, to create an even more conducive environment for businesses by providing predictability and visibility. Mr. Speaker, sir, to attract foreign direct investment, we need to continuously adapt ourselves to evolving circumstances, to first retain the existing investors who have chosen our country, and secondly, become more competitive and attractive for new investors. We cannot also be insensitive to the demographic challenges that our country is facing, with a natality rate of below 1.4. Last year, we came up with several measures to further open the economy for investors and retirees. The Finance Bill amends the Immigration Act to align the validity period of an occupation permit for professionals to that of investors. That is, for a period of 10 years. This will give more certainty to both employees and employers. Our country needs foreign talents to further develop particularly emerging and innovating sectors. In the same vein, the age limit for a dependent child is being waived for as long as the child is dependent on the main holders. This will prevent investors and professionals from leaving the country because of their children having to leave. The Immigration Act is also being amended to provide for residence permits to non-citizens buying an apartment for at least $375,000 US. This will align investment in apartments with other real estate schemes, such as the Property Development Scheme. With a view to attracting high net worth families to Mauritius, and who could eventually opt to do business in and from Mauritius, the Immigration Act is being amended to introduce a family occupation permit where the family will be required to contribute $250,000 US in the COVID-19 Projects Development Fund. In addition, holders of a 10-year permanent residence permit before 1st September 2020 will be extended to cover a period of 20 years in alignment with those issued with the permit after the 1st of September 2020. This measure is in line with our strategy to retain investors and professionals who have demonstrated successful contribution to our economy. Mr. Speaker, sir, as a response to the impact of the COVID-19 pandemic, we also introduced the premium visa, allowing tech-savvy professionals to blend their vacations with work in Mauritius. Le Figaro publication in France recently ranked Mauritius 4th amongst the most sought-over destination for retirement by French citizens. The premium visa scheme was introduced in November 2020 to attract eligible non-citizens to come to Mauritius to live in a COVID-safe environment for a period of 1 year with the possibility of renewal thereafter. 685 applications for premium visa have been received as at 30th of June 2021. The premium visa targets, amongst others, repeat tourists planning to retire and migrate to Mauritius, investors and professionals willing to come with their family and carry out their businesses or work remotely from Mauritius, or offer their staff this facility, and those having their children studying in Mauritius. In this perspective, the Economic Development Board has been working in close collaboration with the Mauritius Tourism Promotion Authority to develop an integrated marketing strategy to promote Mauritius as a safe location. In order to make the premium visa scheme attractive and to avoid any administrative hurdle, a holder of a premium visa spending 183 days or more in the Republic of Mauritius is taxed only on amounts of his income that is brought and deposited in a bank account in Mauritius. Money spent in Mauritius through the use of foreign credit or debit cards is not liable to tax. Given that Mauritius operates a unilateral foreign tax credit mechanism, there will be no double taxation of income. The Non-Citizens Property Restriction Act is being amended so that approval of my office is not required for disposal of property under the EDB schemes, such as the Property Development Scheme and the Integrated Resort Scheme. However, the EDB will have to notify my office of such disposals. Moreover, provision is being made for the EDB to maintain a non-citizens property restriction register containing particulars about the acquisition or disposal of properties by a non-citizen and if there is any security that has been taken on the property. The Act is also being amended so that no authorization of my office will be required for the initial 20-year lease only. And for subsequent renewals, authorization of my office will be required. Mr. Speaker, sir, I will now comment on some of the other amendments proposed in the bill that relate to departments, again falling under my responsibility. The Civil Status Act is being amended to enable the issue of civil documents such as birth and marriage certificates online through the MoCloud platform, thus avoiding the need for people to call at the civil status offices and queuing up for a document. This is in line with our strategic objective of bringing our services to the people. Another amendment being brought to the Civil Status Act will require hospitals, private health institutions, and midwives for births at home to notify the Civil Status Office of the birth of a child through a prescribed form. Presently, following the birth of a child, the concerned hospital or private health institution issues a document to the parent to be remitted to the Civil Status Office for the declaration of the child within the prescribed delay. However, the document issued by public hospitals and private health institutions are different and therefore do not necessarily contain the same information. With this amendment, a standard form is being introduced to be used by all institutions concerned. With the amendment, the Civil Status Office will receive a copy of the notification of birth when same is remitted to the mother. This measure will also be applicable for midwives who assist in the delivery of a child at home, although such cases are very rare nowadays. The amendment will not only allow the Civil Status Division to have updated information on birth, but will also reduce, to some extent, tardy declarations which constitute a real problem today. Mr. Speaker, sir, the main objective of the United Nations Financial Prohibitions, Arms Embargo and Travel Ban Sanctions Act 2019 is to enable the government of Mauritius to implement targeted sanctions and other measures imposed by the United Nations Security Council with a view to addressing threats to international peace and security, including the financing of terrorism and proliferation of weapons of mass destruction. The proposed amendments to the United Nations Financial Prohibitions, Arms Embargo and Travel Ban Sanctions Act are meant to strengthen existing provisions to avoid any ambiguity that might arise, as well as to better empower the National Sanctions Secretariat to conduct its duties diligently. Mr. Speaker, sir, the proposed amendments to the ICT Act 2001 are being brought to ensure improved compatibility of the local legislation vis-à-vis the international commitments taken at the level of the World Trade Organization, notably with regard to the integration of the regulatory principles formulated under the WTO Telecommunications Reference Paper. The issues that are being addressed are in relation to the notion of essential facilities and universal access. Corresponding sections on universal service, interconnection and access agreements, market definition, and tariffs are being reviewed to address functional limitations identified by the ICT Authority. The ICT Act is also being amended to address issues raised in the report of the Commission of Inquiry on Drug Trafficking, published in year 2018, regarding the use of satellite telephones, which, according to information received, are being used by traffickers. Mr. Speaker, sir, through the COVID-19 Miscellaneous Provisions Act 2020, various enactments were amended to cater for the impact of COVID-19 and to provide for matters connected, consequential, and related thereto. The Interpretation and General Clauses Act was thus amended to define the COVID-19 period as follows, I quote, "The period starting on 23rd March 2020 and ending on 1st of June 2020 or ending on such later date as the Prime Minister may, by regulations prescribed under this Act." End of quote. Following the resurgence of the COVID-19 pandemic this year, the COVID-19 period has to be redefined. The Interpretation and General Clauses Act is therefore being amended to include the confinement period for the year 2021 in the definition of COVID-19, and also to make provision for the COVID-19 period to be defined by way of regulations for any subsequent year. Mr. Speaker, sir, the Prevention of Corruption Act is being amended with a view to enhancing the effectiveness of the Independent Commission Against Corruption in the fight against money laundering and to facilitate asset management and recovery, which is an important component in the context of FATF and ESAMLAG evaluation of the effective compliance of Mauritius with FATF AML CFT standards. In this context, the validity of attachment orders is being extended from 60 days to 6 months to address the challenge of having to continuously apply for an extension of existing attachment orders, thus burdening the court with repeated applications for renewal. Money laundering investigations, especially complex ones, as well as those with international ramifications, often take time, and the 60 days validity period of such attachment orders is often too limitative. Moreover, the proposed amendment will enable the Commission to realize assets which have been attached or seized by it in the course of an investigation, and will address the issue of security and wear and tear of these assets which are kept within its compound. The realization of those assets will allow for the preservation of the value of those properties, as they will not be subject to depreciation. Mr. Speaker, sir, presently only the Financial Intelligence Unit can apply for an account monitoring order under Section 49 of the Asset Recovery Act. An application for an account monitoring order may, amongst others, specify information relating to all accounts held by a person at such financial institution, or description of accounts held. With a view to strengthening our AML-CFT framework, the Prevention of Terrorism Act is being amended to allow a judge to also make an account monitoring order on an application made by the Commissioner of Police. Mr. Speaker, sir, in line with the recommendation made at paragraph 7.13.9 of the report of the Commission of Inquiry on Drug Trafficking in Mauritius, as from 1st February 2019, cigarettes have been banned in prisons. Clause 76 of the bill will give legal effect to that decision by amending Section 26(1) of the Reform Institutions Act. Mr. Speaker, sir, the Public Collections Act dates back to 1965. This legislation regulates the raising of funds for medical, social, religious, and charitable purposes, amongst others. Amendments are being brought to Sections 2 and 6 of the Act with a view to combating money laundering and financing of terrorism, and to be in line with the guidelines of the Financial Action Task Force. Besides preventing money laundering and financing terrorism, the amendment of Section 6 has also a compassionate dimension, as it allows promoters, particularly those raising funds, to undergo urgent medical treatment or surgery abroad, 6 months to submit their detailed statements concerning expenses incurred for such purposes, as compared to 1 month previously. The tight deadline was adding pressure to their already precarious situation. Moreover, a promoter who, in the event of a force majeure, cannot meet the obligation of submitting the detailed statement of expenses incurred for the collection and the manner in which the proceeds have been disposed of, is also being allowed an additional period of 6 months for the submission of these statements. However, to prevent any abuse, the extension will be granted only if the promoter has taken all reasonable precautions, due care, and reasonable alternative measures to avoid the effect of any circumstance or event which would affect his ability to fulfill his obligations. Mr. Speaker, sir, the Civil Aviation Act is being amended to provide that henceforth the passenger fee and the passenger solidarity fee to be levied in US dollars instead of Mauritian rupees. Mr. Speaker, sir, let me come to the proposed amendments to the Gambling Regulatory Act. And I will dwell quite lengthily on these amendments to dispel all doubts and apprehensions, and also to denounce the demagogy going on at the moment. At the outset, I will say that all the hue and cry with regard to the proposed setting up of a horse racing division within the Gambling Regulatory Authority is totally unjustified. It is a known fact that horse racing in Mauritius is at crossroads. Either we undertake a complete overhaul for a better or sustainable future, or we let the industry die an inexorable death with no sensible and responsible person would wish. Mr. Speaker, sir, serious concerns on horse racing in Mauritius have been expressed since many, many years. I have on various occasions in the past denounced the malpractices and integrity issues that have prevailed for so long. The former Prime Minister, Dr. Navin Ramgoolam, while replying to a parliamentary question on 22nd of July 2014, stated, I quote, "Government views with great concern the wide-ranging allegations about the organization and management of horse racing in Mauritius. Government is equally concerned about criticisms leveled at agencies dealing with horse racing and betting activities related thereto. It is very obvious that public confidence in the integrity of the horse racing industry has been severely dented. I have decided to set up a commission of inquiry to look into all aspects of horse racing in Mauritius." Unquote. Subsequently, the previous government announced on 24th of September 2014 the setting up of a commission of inquiry on horse racing in Mauritius, and the then President of the Republic appointed Mr. Richard Parry as commissioner to chair the inquiry, with two fellow commissioners, Mrs. Dennis Gunn and Paul Scotney, to act as assessors. The Commission submitted a damning report in March 2015, only 3 months after l'Alliance Les Peuples assumed office after the December 2014 general elections. It confirmed the ills plaguing the horse racing industry. It mentioned maladministration, corruption, collusion, conflicts of interests and clans, race fixing, and, Mr. Speaker, sir, so many other malpractices. The Parry report highlighted the following, I quote, "The Commission notes that allegations of corrupt races have been a major issue for Mauritian horse racing for many years. Common themes that were highlighted in the Rowe report in 1985 and in the view of the Commission are still relevant, include clarity around whose responsibility it is to deal with corruption in horse racing, the inability through the structures and processes of the MTC to adequately deal with the issue of fixed racers, conflicts of interest that inhibit improvements around integrity, the management and control of both Mauritian and foreign jockeys, the illegal betting markets, and inadequate application of the rules and regulations around corruption." Unquote. The Commission considered that the GRA was not fit for purpose and required a fundamental overhaul with more dynamic leadership, a clear strategic plan to fulfill its wide-ranging responsibilities under the GRA Act, tactical options for implementing its strategy, and crucially, needed to be properly resourced with experienced and motivated staff. The Commission recommended that there was an urgent need to remove the regulatory and governance responsibilities from the MTC and instead create a separate organization, the Mauritius Horse Racing Authority, which would be a new independent statutory body to oversee the regulation and governance of horse racing in Mauritius. The Commission felt that there was merit in consideration being given to changing the MTC's status from a private club to a company limited by shares under the company law. It also recommended better coordination between the GRA, the MRA, the FIU, and the Police des Jeux to effectively deal with malpractices and corrupt activities in the horse racing industry. Monsieur le Président, comme je l'ai dit, ce n'est un secret pour personne qu'année après année, l'organisation des courses a été décriée par tous les stakeholders concernés. Rapport après rapport, d'Euro à Paris, en passant par Balgobin et Glover, le constat a été unanime et accablant. Les courses hippiques à Maurice souffrent de pratiques douteuses. Les turfistes ont été les plus grandes victimes. Monsieur le Président, il fallait agir. Le gouvernement a commencé à prendre le taureau par les cornes dès le début de son mandat en 2015. Et comme recommandé par le rapport Paris, il fallait donner à la GRA des muscles et des dents pour évoluer d'un bulldog sans dents à un bulldog qui sait mordre. Si la GRA n'était pas fit for purpose en 2014, comme mis en exergue par la commission d'enquête, c'est que cette institution régulatrice n'avait qu'une dizaine d'employés, la plupart des retraités qui ne faisaient que du rubber stamping sous le joug d'un nominé travailliste qui agissait comme chairperson. Pas besoin de mentionner des noms. Il fallait nommer un nouveau conseil d'administration, restructurer l'institution et recruter des personnes compétentes ainsi que des consultants pour aider la GRA à assumer ses responsabilités pleinement. Aujourd'hui, la GRA est dotée d'un conseil d'administration dynamique et proactif et d'une cinquantaine d'employés qualifiés. Depuis 2015, la GRA a pris une série d'initiatives pour mieux exécuter sa mission, telle qu'énoncée dans la GRA Act. Ces initiatives ont tenu compte des observations et recommandations de la Commission Paris. Ainsi, selon les provisions de la loi, des directives ont été émises à l'intention de l'organisateur des courses hippiques pour s'attaquer aux problèmes de subjectivité et d'iniquité dans la prise de décision et d'apporter plus de certitude aux stakeholders concernés. La loi a été amendée pour contraindre les opérateurs du betting d'opérer à travers une entité coopérative pour plus de transparence et conformément à la réglementation contre le blanchiment d'argent. C'est dans cette même optique que le MTC, qui a un statut de club privé, a dû créer une subsidiaire coopérative, le MTCSL, pour pouvoir opérer selon les nouvelles dispositions de la loi. Le contrôle antidopage a été renforcé, la GRA prenant à sa charge le contrôle hors compétition. Sur une recommandation du laboratoire concerné, le contrôle pré-compétition est fait les jeudis suivant la publication du programme des courses. Ce nouvel arrangement permet au laboratoire d'avoir plus de temps pour effectuer un éventail de tests, contrairement à ce qui se pratiquait auparavant. Monsieur le Président, depuis septembre 2017, 27 cas de dopage ont été détectés. Pour plus de transparence sur les gains issus du betting, les licensees de la GRA sont contraints sous l'Income Tax Act de répertorier les gains dépassant 20 000 roupies. Des accords de partenariat, des MOUs, ont été signés entre la GRA et d'autres institutions, comme la MRA, l'ICAC, la FIU, l'IRSA, en vue d'une collaboration étroite pour mieux traquer les actes illégaux ou suspicieux dans le circuit des jeux du hasard et d'argent. Désormais, il est un devoir légal des licensees de la GRA de divulguer leurs bénéficiaires ultimes, ce qui permet de connaître l'identité de la personne qui est réellement derrière l'activité concernée. La Personal Management License a été introduite afin de déterminer si une personne engagée dans le secteur des jeux de hasard et de l'argent est fit and proper. Son importance est maintenant mieux comprise, car l'exercice de due diligence qui précède l'octroi de la Personal Management License permet de mettre à l'écart des individus suspectés de ne pas être fit and proper. La loi a été amendée pour contraindre les institutions financières à ne pas honorer des transactions liées à des paris illégaux sur le net. Et dans peu de temps, la police des jeux passera sous la GRA en vue d'une meilleure coordination en ce qu'il s'agit des opérations coup de poing sur le terrain. Et finalement, il y a eu l'introduction d'un mécanisme de contrôle en ce qui concerne l'achat des chevaux, les paiements effectués aux jockeys et les versements pour l'entretien de chevaux, communément appelés keep money. Désormais, toutes ces transactions, de par la loi, doivent passer obligatoirement par un compte spécifique de la MTCSL. La responsabilité incombe donc à la MTCSL, valeur du jour, de rapporter à la FIU toute transaction qu'il jugerait suspecte. Toutes ces mesures montrent que les autorités se sont armées de dispositions légales et de mécanismes pour combattre des actes illégaux dans le secteur des jeux de hasard et d'argent, susceptibles de ternir l'image du pays. Évidemment, ces mesures ne plaisent pas à cette mafia dénoncée par la commission d'enquête Paris. C'est pour cela, Monsieur le Président, qu'il y a autant de résistance. Et aujourd'hui, Monsieur le Président, à travers les amendements proposés au GRA Act, c'est une autre étape cruciale qui est franchie pour mettre de l'ordre dans l'industrie hippique et assurer sa pérennité. Passer à cette nouvelle étape est nécessaire, car il y a encore des entorses répétées aux règles régissant les courses hippiques, au détriment des principaux acteurs du secteur que sont les entraîneurs, les propriétaires des chevaux et surtout les turfistes. Inspiré par l'une des plus importantes recommandations de la Commission Paris, nous proposons la mise sur pied d'une Horse Racing Division à la GRA. Nous ne créons pas une nouvelle autorité parce que nous estimons inapproprié de dupliquer les institutions, compte tenu de l'exiguïté de notre juridiction. Nous sommes d'avis qu'il faut bâtir autour de ce qui existe et optimiser l'utilisation des ressources disponibles. Cependant, il est important de souligner que la Horse Racing Division opérera en toute indépendance pour assumer les regulatory and governance functions des activités hippiques. Le responsable de cette division consultera le CEO ou l'officier en charge de la GRA que sur des questions d'ordre administratif et de politique générale. De plus, cette division, j'en donne l'assurance, comptera en son sein que des professionnels aguerris en matière hippique. Le responsable de la division a déjà été recruté. Il s'agit d'un professionnel australien qui a mis ses compétences au service de plusieurs juridictions hippiques. Il sera épaulé par d'autres consultants réputés dans leurs spécialités respectives. Évidemment, des professionnels mauriciens y feront aussi partie après des exercices de recrutement. Mr. Speaker, sir, as I said when starting to speak on the amendments to the GRA Act, there is nothing sinister in what we are doing. There is an urgent need for reform and change in the horse racing industry. While recognizing the contribution of the Mauritius Turf Club in horse racing, we cannot turn a blind eye to the numerous concerns expressed by stakeholders of the industry, and as I say, especially of racegoers. I wish here to allay the fears of those who have been made to believe that government wants to take horse racing under its control. This is absolutely not true. Government is only ensuring that horse racing is undertaken in an environment of trust where integrity, fairness, and transparency will prevail. Some members on the other side of the House have said, à qui profite le crime? Well, first of all, there is no crime that is being committed. What is being proposed is an evolution for a sustainable and clean horse racing industry. Mais je pose des questions aux membres de l'opposition. À qui profite le crime qui est en train d'être perpétué semaine après semaine à l'encontre des tuafistes? À qui profite le crime de continuer avec des décisions arbitraires et des collusions occultes? À qui profite le crime quand certains cautionnent les maldonnes et les activités des corrompus qui ont pris des courses en otage? On sait, Monsieur le Président, comment les gains provenant des courses hippiques ont servi de war chest pour des politiciens au sein de l'opposition, parlementaires et extra-parlementaires. On sait aussi les relations incestueuses entre ceux d'hommes dénoncés dans le rapport de la commission d'enquête et les politiciens de l'opposition. On sait comment des politiciens de l'opposition ont donné des consignes de vote aux dernières élections au Mauritius Turf Club. Ils ont affiché ouvertement, publiquement, à travers leur compte de Facebook. Alors, ce n'est pas difficile de comprendre les motivations de certains membres de l'opposition. Ce sont eux qui ont politisé le MTC. Qu'ils fassent leur mea culpa avant tout. Monsieur le Président, si je comprends bien les critiques de l'opposition, dois-je conclure qu'ils auraient mis le rapport Paris dans un tiroir si jamais ils avaient gagné les élections en 2014? Auraient-ils trouvé une parade pour dire que le commissaire et ses assesseurs ont fauté et qu'il fallait à tout prix maintenir le statu quo et laisser pourrir la situation? Aurait-il permis à la mafia dénoncée dans le rapport Paris de continuer à détrousser les tuafistes semaine après semaine? Quant au Mauritius Turf Club, maintenant Mauritius Turf Club Sports and Leisure Limited, je ne peux que condamner cette obsession de vouloir à tout prix défier le gouvernement et la GRA. Je le redis, le gouvernement agit en toute bonne foi pour le bien des courses hippiques. Et au lieu de contester à tout bout de champ, le MTCSL gagnerait à reconnaître qu'avec la mise sur pied de la Horse Racing Division, il serait épargné des dépenses conséquentes liées au contrôle antidopage et de sa facture salariale la plus onéreuse. Et loin de vouloir tuer le MTCSL, comme allégué, l'opportunité est donnée à ce dernier de mieux utiliser les ressources financières qu'il continuera de recevoir des opérateurs de paris pour améliorer ses infrastructures, moderniser ses équipements, augmenter les stakes money, améliorer les conditions d'emploi des palefreniers par exemple, ou encore planifier l'avenir. Contrairement à ce qui est dit par le président du MTC, un fait avant du MMM, le MTCSL continuera à s'occuper de l'organisation des courses, des Race Day Operations, comme on le dit. Depuis la parution du programme officiel jusqu'à la fin d'une journée de course, le MTCSL continuera de s'occuper de ce qu'il fait maintenant. Clairement donc, la mise sur pied de la Horse Racing Division sera un game changer, non seulement pour l'industrie hippique, mais aussi pour le MTCSL. Comme je disais auparavant, peut-être en l'absence de, surtout du MMM, c'est connu, Monsieur le Président, que le président du MTCSL, un certain JMG, il n'est pas, je disais, un très proche du MMM. Il est un membre du MMM. Il est très très proche de son leader. Et je vais prouver ce que je suis en train de dire. Mais moi, je ne fais pas des allégations ou bien je ne viens pas dire des choses que l'honorable Bagwan et l'honorable Kirin. J'ai lu avec attention leur discours, mais je ne vais pas aller dans les détails pour les répliquer. Mais moi, ce que je dis, je vais prouver ce que je dis. Un proche, un membre du MMM, il avait participé à la campagne électorale 2019. Il y a des témoins ici encore. Il avait pris la parole lors d'une réunion politique du MMM au domaine Camélia, chemin Grenier, le 19 octobre 2019. Et cela avait été rapporté dans la presse. Et d'ailleurs, je profite pour to table a document. It is a certified copy of le défi quotidien. J'ai pris la peine de faire certifier. Voilà ce qu'il dit. Monsieur Giraud qui avait... Monsieur JMG, pardon. Parce que je lisais de ce qui a été rapporté. Monsieur, dans la presse, ce n'est pas rapporté comme ça, mais il faut que je rapporte fidèle au principe parlementaire. JMG, ancien directeur d'une compagnie qui s'appelle U.B.P. Je ne sais pas, peut-être qu'on peut deviner quelle compagnie, est également intervenu, s'il vous plaît. Un meeting politique du MMM. Il est également intervenu. Il a mis l'accent sur le partage équitable des richesses. C'est pour cela, dit-il, que le MMM travaille sur un programme pour promouvoir la justice sociale. Et moi, je peux affirmer ici, il a travaillé sur le programme du MMM. J'attends, il n'y a personne malheureusement, mais j'attends qu'il vienne me dire le contraire. Qu'il vienne me dire le contraire, et puis je vais prouver. Je vais prouver comment, et pas prouver juste par des allégations. Je vais prouver, comme si c'était devant une cour de justice, je vais prouver comment ce monsieur a contribué, lui-même, personnellement, à rédiger le programme gouvernemental du MMM. Hein? Donc, comme je disais, il avait travaillé sur le manifeste électoral en marge des élections de novembre 2019. Et qui plus est, la compagnie où JMG était CEO renfloue régulièrement les caisses du MMM. Et j'attends aussi, peut-être qu'ils vont faire une conférence de presse samedi, j'espère qu'ils vont garder quelques minutes pour me répliquer publiquement ce que je suis en train de dire ici. Renflouer régulièrement les caisses du MMM, la Chambre peut-être va être choquée. Comment des millions atterrissent dans la caisse du MMM. Et puis, ils vont dire que le MMM est le parti le plus pauvre. Le parti le plus pauvre de Maurice, Monsieur le Président. Mais attendons. Attends.
Order.
C'est clair, donc, Monsieur le Président, que JMG et le MMM ont des intérêts communs. Il est surtout question, comme je dis, du war chest. Parce que c'est ça, là, qu'est-ce qui est en jeu, là? Vous savez qu'est-ce qui est en jeu? C'est pas si c'était une question de venir de l'avant avec une loi pour réglementer les courses hippiques. Vous croyez qu'il allait se battre comme ça? Vous croyez qu'il allait mettre toutes sortes de banderoles au champ de Mars? Parce que là, vous savez, qu'est-ce qui est en jeu? Comme on dit, le patient qui est sur le lit et qui a le sérum qui l'alimente et qui le garde en vie, c'est ce sérum-là que je suis en train de couper là. C'est ça. Et c'est ça l'enjeu. Le peuple doit savoir. Ça, ce n'est rien. On verra après. Donc, un enjeu vraiment réel pour le MMM. Et c'est pour cela que les députés du MMM, notamment, comme j'ai dit, les honorables Guirin et Bagouane, sont montés au créneau pour venir répéter dans cette Chambre les allégations malveillantes de JMG contre la GRA et le gouvernement. Il serait aussi approprié de souligner que le DON, dont la Commission Paris a fait mention, avait obtenu son premier permis d'opération, celui de la compagnie Bet Online, de la défunte Horse Racing Board. Vous savez en quelle année, Monsieur le Président? En 2002, lorsque le leader du MMM était ministre des Finances. Attendons voir s'ils vont dire que ce n'est pas vrai. Monsieur le Président, l'honorable Guirin a déclaré lors de son intervention vendredi dernier que selon la section 3515C du Finance Bill, c'est la Horse Racing Division qui sera responsable pour l'organisation des courses. J'ai lu et relu cette section et je n'ai rien trouvé qui dit, comme allégué par l'honorable Guirin, que la Horse Racing Division va organiser des courses hippiques. Au contraire, la section 15C1A se lit comme suit, et I need to quote so that people can understand. The Horse Racing Committee shall ensure that the horse racing organizer effectively discharges its responsibilities regarding the organization of horse racing in all its aspects, including safety, comfort and standards of hygiene, security, discipline, and the prevention of fraud, unquote. Le horse racing organizer n'est certainement pas le Horse Racing Division. Et dois-je comprendre que soit le député n'a rien compris, mais soit il est en train de faire de la démagogie et il est en train d'essayer de protéger son war chest de son parti. Je pense même qu'il n'est même pas au courant. Enfin, je suis sûr, peut-être qu'il n'est même pas au courant. Hein? Tous les mois, je peux vous dire tous les mois combien de roupies rentrent dans la caisse du MMM. Quant aux commentaires de l'honorable Bagouane, je préfère ne pas répondre, Monsieur le Président, à ses attaques personnelles et à ses diatribes coutumières. Mais je ne peux laisser passer son accusation gratuite contre le président de la GRA sous le couvert de l'immunité parlementaire. Et j'espère que, comme je le dis toujours pour certains membres, j'espère que s'ils ont le courage et s'ils sont honnêtes envers les critiques qu'ils sont en train de faire, de les répéter en public, en dehors de la Chambre. Parce que moi, tout ce que je suis en train de dire, je peux à n'importe quel moment aller les répéter en public. Monsieur le Président, je trouve répugnant que certains veulent, par tous les moyens, discréditer la GRA et faire un procès d'intention à la Horse Racing Division qui est proposé. Je le redis, le gouvernement agit de bonne foi et je donne encore une fois l'assurance que la Horse Racing Division sera composée d'experts et de professionnels qui agira en toute indépendance. Mr. Speaker, sir, the comments made by representatives of the Mauritius Turf Club about the nationalization of horse racing are clearly, really, not only they are unfounded, they are, I would say, enfantins. Enfantins. Comme si ils n'arrivent pas à nager, ils sont en train de s'accrocher sur n'importe quel argument qui passe par leur tête. But then these kind of arguments are meant deliberately to create a sentiment of mistrust amongst horse racing followers about the intentions of government and the GRA. What this government truly wishes is for the horse racing industry to adopt integrity and professionalism as the cornerstones of its future development. We want to breathe a new life into an industry which deserves better. Monsieur le Président, la pérennité des courses hippiques passe aussi par la mise sur pied d'un nouvel hippodrome moderne, avec toutes les facilités nécessaires et dignes de notre République avant-gardiste. Sur ce chapitre également, l'avènement de la Horse Racing Division à la GRA ouvre de nouvelles perspectives. Et je peux dire à la Chambre que des discussions avaient été entamées avec le MTC à la demande de celui-ci pour baliser les contours de la nouvelle industrie hippique. Une équipe composée des officiers de mon bureau et du ministère des Finances avait été dûment mandatée pour entamer ces discussions. Je suis informé qu'il y a eu 7 réunions du 2 décembre 2020 au 15 février 2021. Et il y avait consensus sur la marche à suivre, y compris la mise sur pied de la Horse Racing Division, qui assumerait les regulatory and governance functions of horse racing. Il y avait unanimité sur la nécessité d'un nouvel hippodrome. Il y a bien eu un dialogue avec le MTC, dûment représenté par son ancien président et son ancien CEO et 2 consultants, Ernst & Young, dont les services avaient été retenus par le MTC. Il est donc faux de dire qu'il n'y a pas eu de consultation. Si, bien sûr, la nouvelle direction du MTCLCL a changé de cap en s'entêtant dans la provocation et l'insulte et n'a pas voulu poursuivre ces discussions, je ne vois pas comment le gouvernement peut être blâmé. Et certainement, nous ne privilégions personne par rapport à un autre. Notre agenda, c'est le bien de l'industrie hippique, rien de plus. Cela étant dit, Monsieur le Président, je souhaite réitérer que le gouvernement agit de bonne foi en venant de l'avant avec les amendements au GRA, et je suis convaincu qu'en de peu de temps, ceux concernés par l'industrie hippique nous remercieront pour avoir pris des décisions qui s'imposent pour assainir les courses et assurer sa pérennité. Nous faisons ce que d'autres juridictions hippiques, comme la Grande-Bretagne, le Singapour, l'Afrique du Sud, ont fait depuis des décennies. Monsieur le Président, nous avons en tout cas la détermination et la ténacité de mener à bien la réforme à plusieurs volets entamés depuis 2015 dans le secteur hippique. Je veux que cela soit bien compris de tous. Mr. Speaker, sir, before concluding, I wish to congratulate the Minister of Finance, Economic Planning and Development for such a comprehensive finance bill. The sheer number of amendments, 93 in all, reflects the breadth and depth of all actions of this government to address the development issues facing our country, our people, and our businesses. The vast number of amendments also bears out the determination of this government to ensure that at all times our country has a regulatory and legal framework that befits our development vision and the aspirations of the people. I am confident that the amendments in the Finance Bill that will give effect to the numerous measures announced in Budget 2021-2022 will enable us to deal with the pandemic and its fallouts in an effective way. And, of course, we are looking forward to strengthen and speed up the path to economic recovery. Thank you.
Honourable members, I suspend the sitting for 30 minutes.